Gentlemen,
Good morning.
I know we're a little light today because of vacation for schools, but we have a lot of work to do and we're going to get it done. Thank you all for coming and going out of your way to do so. And at this time, I'd like to call on Representative Corzine to lead us in the Pledge of Allegiance. All rise, please.
Pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
I heard a little comment that I think bears repeating. Go Team USA. Thank you all. So this morning I'm going to open the hearings for House Bill 1241 relative to the calculation of income for purposes of support orders in divorce proceedings. I don't have, I have one pink card. There's another one coming. The first pink card is Representative Joseph Barton. I will ask Representative Barton to have a seat and open your bill, introduce your bill.
Thank you, Madam Chair. My name's Representative Joseph Barton. I represent Grafton District 1. Am I on the? Just going to move this a little bit. House Bill 1241. I introduced because going into a long divorce process, if you come from a background where you are the sole provider for your family and you voluntarily work overtime and you're working 60 hours a week or even more, that becomes incorporated ultimately into the final hearing. And if you deviate or drop it down to 40 hours, you can be accused of avoiding support when all you really want to do is spend more time with your kid. So I introduced this bill to make it so that discretionary income or work that takes away from one parent's time over the traditional 40 hours is brought down to one income or one primary income. And that should be considered mainly because it's in the best interest of the child to spend time with both parents, and equally, courts have long decided that it's 50-50 is the best starting point for parents. And when one parent is constantly working because they're forced to, that defeats that purpose. So HB 1241 makes a focused and necessary reform to the definition of gross income under the statutes for the purposes of alimony and child support. The bill clarifies that gross income shall consist of income derived from a parent's primary occupation, including wages, salary, commissions, regularly received self-employment earnings, and it should not include overtime compensation, earnings from secondary employment, or income derived from sources outside of the parent's primary occupation. All of those sources would not be consistent. They could be seasonal. Overtime is never guaranteed. But when you have an order that's based on an estimate of received overtime, and then that overtime all of a sudden isn't there, then you have arrears issues, multiple motions to modify because of changes in that variable income from that stable 40-hour income. Under current practice, when a parent works overtime or takes on secondary employment, often during a period of financial transition following divorce, those additional earnings are frequently incorporated into that final support calculation. And it becomes embedded into the calculation. And now for the rest of, until the child becomes 18, they have to work 60 hours a week. When can they see their kid? It's hard for me because I was in that particular situation and I don't get to see my daughter enough. I love to see my daughter, and without a change in circumstances, I just have to work all the time, and I basically essentially pay to not see my kid, which I don't think is particularly fair.
Thank
Um,
you. Your time is up.
Okay, I did pass around with written testimony, and
Will you
I'll-
take questions?
I'll take questions. Why
Thank
not?
you. Representative Love.
Would you believe that I had eerily similar things happen to me? I was working 80 hours a week in my own business. I'd be installing windows and doors and roofs and what have you, and all day long, and then go out selling stuff at night. Selling more jobs at night, and that was for 2 of the 3 years before before my knee wouldn't let me do it anymore. And the numbers looked real good, and I got whacked with some serious child support numbers to try to live up to, and I couldn't. And I thought I was going to jail. But if this was in place, that might not have happened. I didn't have much time with my daughter either, because of it. And I'm certainly going to be voting for this. Thanks.
I would believe that. And my father had a window and door business, so I understand the strains and pains that go along with that because I worked with him. And I also have received testimony from many constituents in my my district who are facing the same issues and concerns. And we need stability. Stability comes from primary income, not variable, unpredictable income.
Representative Rice.
Thank you, Madam Chair. Thank you for taking my question. So my question is, my husband works in a car dealership. He gets a commission every month. He definitely works overtime because he is salaried. So why is his income excluded from this exemption, yet anybody else who works overtime would be able to get it?
So you're saying he works more than 40 hours a week?
Oh, absolutely. It's how the car business is, right? And he works for a commission, right? So he doesn't have child support anymore, but when he got hit, I had to work 3 jobs so we could survive. But he would not be excluded in this because, if you want to say anybody that works over 40 hours, right, should not have to pay, but then what would he have paid for his kids if his commission isn't included? Do you understand what I'm saying?
His commission would be included, and it is included in this. If that's his primary income, he has to work overtime. Then, is that discretionary? I don't know his personal situation, but if you're working 40 hours a week selling cars and you get what you get for that commission, then that's what it should be based on.
No, in the car business, especially my husband was a general sales manager, you are there from bell to bell many days. That is more overtime, but because he's a salaried employee and gets his commissions, how would they calculate that for him when he in fact is working over 40 hours a week, but it's not technically overtime?
I don't understand. Is he a salaried employee or is he making it on commission? So are you earning money by salary or commission?
He does both, is what I'm saying. He gets a salary, but he also gets a commission. He is a general sales manager, so he also gets commission, but he clearly works over 40 hours, as do many in the car sales business. So what I'm saying is, why would he be excluded when he's working up to 70, 80 hours a week and getting a commission, yet he's not included in this? He's excluded from this, yet you're saying anyone that works overtime should be that income over 40 hours should be excluded.
So salaried employees do not receive overtime compensation.
would you believe that the labor laws are that after a particular amount of hours in a week, even salaried employees shall be compensated?
No.
Okay, well, that's the law. Thank you. Representative Raymond.
Thank you, Madam Chairwoman, and thank you for taking my question. I have another technical question similar to my colleagues regarding some of the definitions of terms that aren't defined in here. So under line 2, it says, means income from the primary occupation. Well, how is primary occupation defined? I'm thinking of individuals like myself who have multiple part-time jobs. Which one of my part-time jobs is considered my primary occupation under this bill?
The one that you work the most, so or receive the most income from. If your first 40 hours.
To follow up, please. So I frequently don't get 40 hours at any of my jobs. I get 15 or 20, and sometimes it varies from week to week because that's how part-time jobs work. So do I get to choose to say this is the one that is the least compensated, but it is the most time, so that's my primary occupation? Or does the judge have discretion to decide that it's the one where I make the most money, even though it's the least hours?
I would say that the judge would have the discretion to determine what your first 40 hours are and which occupations fill those 40 hours.
Last
Typically,
follow-up.
typically most people have a standard 40-hour work week. That's their primary job. Their secondary job is 0 to 20 hours supplemental.
Last follow-up. Thank you. So I'm curious about this 40 hours because it's not in the bill, 40 hours. And when I did work full-time, my full-time hours were 37 and a half. And then once I hit 40, that's when my time and a half started. So that there was like a period of, 2.5 hours that I had to work regular pay before I got overtime. But 37 and a half was my full-time schedule. So I'm curious where the 40 is coming from and if that is elsewhere in state law that I'm unaware of as primary or full-time.
Yeah, 40 hours is standard work week. In France, it's 35 hours, but we're not there. So I'm just going by standard work week.
Representative Malone.
Thank you, and thank you for taking my question. How would this work for people like, and I was late, so if you already said this, apologies, but waitresses, bartenders, people. So like I've waitress and bartended. That's my second job. I work a salary job. But the primary amount, right? People get paid $3, $4, $5 an hour, and all the rest is tips or commission. So how would that get calculated? Plus a lot of them could be cash tips, right? So like when I think about what's on, like at the end of the year, what my waitressing pay looks like compared to what actually was taking in, and it's not guaranteed, right? There are days you make $300 and there are days you make $40. So how would the people that basically it's mostly tips, how would that work?
So how does it work presently? If you go into a courtroom and you have your income, and tips are income and they have to be disclosed. So I don't understand why it would matter if it's cash tips or credit card tips or whatever. However, it's calculated presently for a server or someone with variable income. However, it's calculated presently, that would continue. I guess that would be the same with the auto dealership manager position. There would be no
Pearson.
difference. There are going to be variable incomes as primary salaries, primary sources of income, and that would just go on.
Thank you, Madam Chairwoman. And since what I think I heard will apply to the company I oversee, before I put a call into Ken Merrifield, the Labor Commissioner, I want to nail down, did I hear you correctly? What I thought I heard, what I wrote down is, after a certain number of hours worked, after 40, even a salaried employee could get overtime. Is that what you said?
I didn't say that. The chairwoman said that.
Okay. I'll call for, I think you're right, but I'll call. Nail it down. Okay. Thank you.
And if that is the case, then that extra income would not apply to the overall calculation.
Thank you.
Representative Georges?
Thank you, Madam Chair. Thank you for taking my question. I would like you to know now, because the secondary job the first job may be the primary job. Can it be low according of your second job? Which one we're gonna choose?
So if you're asking if the primary job is a 40-hour work week, low wage, and then a secondary job is less than 40 hours, but you make more money, is that the scenario?
Yeah,
Then the job where you make the most money would be the primary income.
but because, I'm sorry, because here is not say that, it's just like exclude all of those. You just say for the primary, you say just for primary, but you didn't say like if in case, you didn't say that. That's why.
So is that a follow-up?
That's a would you believe.
Okay. Yeah, I guess I don't know how to answer that. If I don't believe it or deny it. I'm sure there are certain cases where you can work a part-time job and make more than I don't understand why you would work the primary job if you're making more doing less work. That makes no sense to me. But I guess entertaining that very rare circumstance, which I can't even think of an instance where that would happen, I would probably quit my first job and start working more hours in the second job. And then that would be my primary and only source of income.
Would you believe that the first job where you make less money may be the job where you get your benefits, and the second job where you make more money, you don't get any benefits, would be the reason that you might do that?
That's certainly a possibility.
Okay,
But
thank you. Representative Corzine and then Representative Love.
Thank you, Madam Chair. Thank you for being here to answer my question.
Sure.
I just looked up RSA 45819, and isn't this already in there? The overtime exclusion?
If it is, then I certainly am not affected by it. I was forced to work extra hours for 3 years under a temporary order.
Okay, thank you.
Representative Love.
Thank you, Madam Chair. Regarding Representative Rice's questions about commissioned employees and working overtime, and would you be okay with an amendment to say somebody's working 60 hours a week? Okay, and naturally you're saying you don't want to go over 40. Well, we cut the earnings by a third. 20, 40, 60. We'll cut those earnings by a third, and that'll be the 40-hour base for determining how much somebody has to pay.
I would be amenable to something like that, but the overall goal is to make it so that the parent paying the support actually has time to spend with their child, and they're not just working and slaving all the time to because they got stuck in a scenario where they're working overtime all the time, and now that's their life. I want parents to be able to spend more time with their children.
Thank you.
So my question is, did I hear you say that you wanted more quantity of time with your children?
Yes, I would like more time with my daughter, and I'm sure other parents would like more time with their children that they don't have available to them because they're working all the time.
Okay. So my other question is, would you believe that as far as children's attitudes and beliefs are, that quality of time is way more important than quantity?
No, I would not, because the standards that have been through the courts have been 50-50, and I certainly would like more time with my daughter. My daughter asks to see me all the time, and she doesn't get to.
Would you believe that when I was a young parent with young children, my husband and I made a choice that he would work more and I would stay home with the children? However, now that they are adults, they value more of the quality of time they spent with their dad than they did the quantity of time.
Certainly in a relationship where both parents are married or cohabitating, no, those circumstances. I mean, that's how it was when I was married. I'm not married anymore, and the household is divided. So the time should be divided, and I don't think it's applicable what the hearsay testimony from your kids. Certainly, my daughter wants to see me more, and she can't.
I'm sure she does. And I will go to my grave believing that it's because of the quality of time that you spend with her that she wants to see you so much. Because it sounds to me like you're a good dad. So thank
Was
you
that
very
a question?
much.
Oh.
That would you believe?
I would believe that, and I am a good father. Thank you.
Representative Pearson.
Thank you, Madam Chairwoman. And would you believe I'm having a bit of a mental conundrum here, because you're saying, and I believe you want to spend much more time with your daughter. You believe a lot of divorced dads want to spend a lot more time with their kids. So why are we talking about overtime?
Because overtime takes away from one's ability to spend time with their child if they're working an extra 20 hours a week.
Follow up.
And
Then why are you doing it? Why don't you not have it?
I'll
and
tell you
spend
why.
the time?
Because before I got divorced, and I'm going to get personal here, before I got divorced, I was the sole income earner for my family, which included my stepson, who wasn't even my charge. And so I'm working to feed several mouths, and in order to do that, I had to work overtime and extra hours and travel, which meant I didn't get to see my family as much because they required me. After the household is split, all of that changes. But the court recognizes that, no, Mr. Barton, you have to continue to work the same amount that you always worked, and we're going to keep that so we can maintain everything the same. And so I'm stuck working as much as I can until circumstances change and I can make a motion to modify. But until those changes, I'm stuck, and that perpetuates. Certainly during the whole almost 4 years, I was stuck in that position where I had to work all the time, and I had to pay enormous amount of money to not see my kid, and I resent that, and I think that if we had legislation that directed the courts to establish a 40-hour standard, then I wouldn't have to work as much and I can see my daughter more.
Thank you. Thank you for your time, and thank you for answering all those hard questions.
Thanks. The hardest one was deciding whether to take questions.
I'm sure. Thank you. The next pink card I have is for Matthew Hayes. Thank you for coming, Mr. Hayes. We have about 5 minutes, so if we get into questions after you use up your 3 minutes, I may interrupt and open and close the next bill and then come back to you if that's okay.
Thank you, Madam
Thank you.
Chairwoman. That's fine with me. I can keep my testimony fairly short. I do have some written testimony that I'm
Perfect.
going to submit that goes into more detail. I guess really what I wanted to point out, and I should introduce myself, Attorney Matthew Hayes from the Bureau of Child Support Services. Thank you for giving me the opportunity to speak about HB 1241. 2 points I think I'd like to make that's in the written testimony is that the child support portion of this bill could conflict with federal law. There's some requirements in the Code of Federal Regulations, the CFRs, and I have the citation in my written testimony, but it basically says that when establishing child support guidelines, states must at a minimum provide that child support orders based on the non-custodial parent's earnings, that's the language that's in the statute, and other evidence of ability to pay that takes into consideration all earnings and income of that parent. So when this body enacted the child support guidelines, the New Hampshire legislature, defined gross income broadly to meet that requirement. And it seems to me that categorically excluding a number of sources of income. So I know a lot of discussion was on overtime, but if you look at the definition later on, you can see there's a lot of stuff in there. It's a pretty big list of different sorts of income that a parent could have. And to exclude categorically all that, I think would be not compliant. And I think the other thing that this committee should consider is the goals of the child support statute in the first place. And if you look at the preamble of 458C, you can see that the legislature listed out some goals and some principles. And one of the principles is to minimize the economic consequences of a divorce or separation on the children, and to ensure that they enjoy a standard of living equal to that of the parent's subsequent family. And that citation is in my written testimony as well, 458C1. And I'd say that the current definition of gross income is consistent with that principle that's laid out. And that sounds, it would seem to me that HB 1241 is not so much in harmony with that. So I'll conclude with that. I do have, like I said, I have copies for everybody, 16, I think. I'm happy to answer questions and stick around if I need to answer more later on.
Thank you. Representative Rice.
Thank you, Madam Chair. Thank you for taking my question. Can you please explain to me, would this work for both sides? Because when they're calculating child support, they take both incomes into consideration. So would the other parent's overtime be negated also?
Thank you for the question, Representative Rice. That's how I read it. So the definition applies to both parents, and it would include all those things. So if there was overtime that the obligee parent had, it should be included if appropriate.
Follow up, Madam Chair?
Follow up.
Could that then in turn cause the other parent to have to pay more if they're making more in that 40-hour week regardless? Because if the other parent's 40-hour a week, I had to bartend. I had to do overtime just to make ends meet so I could raise my kids. Would that, by removing that overtime for the other parent, is that now causing the other parent, am I making any sense, to have to pay more?
Yeah, I understand what you're saying. I guess I think the best way to answer the question is that I think the idea here is that the court needs a full picture of what's going on with the parents' income. And whether that means the obligee happens to make more or the obligor happens to make more, or however it turns out with respect to what the court decides, what to ultimately do with the child support guidelines, to not allow the court to consider potential other aspects of the family's financial picture, I think is just going to yield results that probably aren't what we want for the citizens of New Hampshire.
Before I take your question, I'm going to go into recess for House Bill 1241. And I'm going to open House Bill 1263. And I'm going to recess House Bill 1263. And I'm going to go back into reopening and coming out of recess for House Bill 1241. And then I will call on Representative Levesque for her question.
Thank you, Madam Chair, and thank you for taking my question. You mentioned that in the RSA as of now has much more listed as for gross income of what qualifies for gross income, and this taking away a lot of that. Do you see that causing an issue when it comes to calculating the child support when it comes to gross income?
Yes, thank you for the question. And I think that I think what I said on the last question, I think also applies to your question as well, Representative, is that you need the full financial picture to come up with equitable guidelines that are going to actually make sense and be workable. And if you only can use portions of party's income, again, obligor and obligee, it's not going to yield a result that I think is equitable or that's going to be fair to the parties.
Any further questions? Thank you very much, and thank you for sending your written testimony in.
Should I just hand it to I have physical copies.
Yes. You can hand them to Representative Malone, please.
All right, thank you.
Thank you. With that, I will now close the hearing on House Bill 1241. I will now open the hearing on House Bill 1263. And I'm going to ask Representative Maggiore to introduce his bill. So he does. Thank you and good morning. You'll have 3 minutes, sir.
Thank you, Madam Chairwoman. Thank you, honorable members of Children and Family Law. For the record, my name is Representative Jim Maggiore, representing the wonderful and now buried in snow town of Northampton. And it's an honor and a pleasure to be here today to introduce House Bill 1263, relative to the definition of disposable military retirement pay and the suspension of alimony obligations. And while I did ask, Madam Chair, for 3 minutes, recognizing the people behind me and being involved so much with their testimony and being involved with their cases, learning so much from them, I might just summarize my comments and hand you my written testimony, because their testimony, I think, is where the real value here is. What we're looking to do with this bill is actually quite simple. Military retirement pay is not a pension. We are just simply trying to codify, put in law, that this is pay. And so that when the court is trying to consider or considering alimony in a divorce settlement, they recognize that this is not property. This pay is not property, it is simply pay. And I think what the testimony that you're going to hear from the folks behind me and all the information that they can provide, I hope will impress upon you why this is so important. And with that, I think I'm going to cease my comments again, because I think knowing the people who are going to speak and being respectful of your time, that it'd be better to hear from them. But that said, I'm happy to take any questions.
Thank you, Representative Rice.
Thank you, Representative. Thank you for taking my question. So how does this bill align with federal USF, SPA, blah, blah, blah? How does it align with that federal thing? And could there be preemption issues?
Well, I don't think there could be preemption issues because the federal law allows the states the discretion to make these decisions. And so that's what we're trying to do right now, is we're trying to, I'm not sure what the word I want, codify? I don't think that's the right word that I'm looking for, but we're trying to establish or codify that this is pay and not property for the courts to have that latitude.
Follow up?
Oh, I lost it. Where did it go?
It's there.
Dang.
Representative Raymond.
Thank you, Madam Chairman. And thank you for taking my question.
course.
Last session, we had a substantially similar bill. We had a lot of testimony about it from military spouses who had given up work for years while they supported their spouse's deployment. And our committee had a lot of questions at that time. I'm curious if you know what the difference is between what you're submitting here and what we ITL'd last year.
Yes, the difference is I was stupid last year, and I'm only a little much less stupid now.
Language? Are there language differences?
Yes.
Okay.
And that's the stupid part. Is if you'll notice, last year's bill said military pensions.
Okay.
This is not a pension, and I think that's where we lost things. That military retirement, sometimes called military retainer pay, and I've learned the difference there, is not a pension. And when we were in our deliberations, in our consideration last year, we were viewing this pay, this bucket, as it was equal to a pension. It is not at all. And that's the distinction that we are making this year.
Okay. Thank you.
The monies received by the person who is now retired, this retirement pay, is this retirement pay reportable as income on a 1040,
I think it's a 1099.
on any IRS reporting of income forms?
Yes.
So I'm going to give myself one follow-up and then go to the next person that may have a question. So in that case, this money, however you term it, is considered income according to the federal government, correct?
And I'm going to defer that question. If we can hold, the folks behind me, I think will give you a deeper, more comprehensive answer than I could.
Thank you. Representative Love.
See, only slightly less stupid than I was last year. Slightly.
I don't believe you were ever stupid.
Thank you, Madam Chair, and thanks for taking my question. Is there anything a retired military person could do that would cause them to forfeit this retirement pay?
To the best of my knowledge, once you are retired from the military, you are still subject to all the rules and regulations of the military, and therefore you could lose this pay, yes.
Follow up?
So this isn't really a general pension like you'd get from the Teamsters or any other organization?
Correct, and that's the distinction that we are making. This is not a pension. This is pay that you receive monthly, therefore it's not property that you get. And if you are called back into service, or that you can be called back into the service in the military, that's what I understand, not a veteran. So I can't, the folks behind me can speak to that.
Thank you, sir.
Thank you. I keep forgetting to say thank you for asking the question. I'm so sorry.
That's okay.
I am so sorry.
We know you're not thankful, because I wouldn't be if I was there. I know I was in the hot seat. You are thankful. Thank you very much. Representative Georges.
Thank you, Madam Chair. Thank you for taking my question. I just want to know if the divorce came just in the time of retirement, what's gonna be?
If thank you for the question. And if I understand your question, you're asking if the divorce happened at we'll say the same time as the retirement.
Yeah.
How are you asking how the
Yeah, what-
courts would recognize
Yeah,
that?
how you gonna pay how they're gonna pay the spouse?
If you know what, I'm making an assumption about the answer to that. And I think, again, the folks behind me can speak specifically to it, but I don't see where there would be any, I would think that the courts would still have all the same latitude in their judgment for creating alimony, and that time stamp. You know, I should stop talking because I really don't, I'm guessing right now at what that answer is. So I'm going to stop talking because it just won't help if I keep going.
Representative Pearson.
Thank you, Madam Chairman. Thank you for taking my question. Given your manifest annual increase in wisdom and knowledge, are you running again?
Are you talking to me?
Yes, sir.
Thank you for the question. Not germane.
Thank you. Thank you very much for your testimony and your ability to answer so many questions and also defer. Thank you.
I have one more question of the chair, if I may.
Certainly.
Lasagna is being offered after I heard about your lasagna. It is here. I have a
Not
spoon.
today.
I have copies of my testimony that I'll hand out.
We would all appreciate that. Thank you.
Thank you.
The next card I have is Anna Goulet Zimmerman.
Is that better? Good morning, Madam Chair, members of the committee. I asked for 2 minutes. I hope you'll allow me to amend that to 3.
You will be given 3 minutes.
Wonderful, thank you. So first, my name is Anna Goulet Zimmerman. I am an attorney that practices in Manchester. I very happily do not do family law cases anymore, but I did for a long time. And I wrote a paper many, many years ago called Divorce in the Trenches, which kind of made me, I was the person for about a decade that when people had questions about how can we do this military retirement, what happens with this, I would get calls. I'd get calls from mediators at mediation saying, hey, how does this work? And I think it was largely just because I had a military spouse. I worked for many years right outside what was Fort Hood at the time. I think it's Fort Cavazos now. So I had a lot of experience overlapping with the military issues. And I came up here and I'd find decrees that were just, well, wrong because they were inconsistent. Like people had agreed to them, but there were problems with them as far as how the military stuff was applied. So full disclosure, as I said, I am a divorced military spouse. I did not receive any of my ex-husband's pension, didn't ask for it, military retirement pay, whatever you want to call it. Didn't ask for it. We didn't have a lot of years. We only had about 8 years that overlapped the military. So I've got no dog in this fight, but I have seen this from many, many different angles over the years. First, I want to talk about the career implications for military spouses. Military spouses are subject to getting moved all the time, sometimes every 3 years. As I said, I got divorced, so I've been able to have a career here where I built up a firm and did that. I have friends who have practiced in 8 different states, and they're never anywhere long enough to get their own pension, to vest in their 401k match, to become senior in the positions they have. They're just doing the best they can at different law schools around, or different states around the country in their legal careers. Most people can't even do that.
Most people are working on base in the stores, in service jobs, just doing what they can to help support their family. Well, their primary concern is taking care of their kids while their spouses are deployed, working, sent away for training missions, and they never get the chance to build up this kind of reserve of retirement. So that's my first issue with this bill. Second, huge disparity in how we deal with military and non-military pensions for property division. This is a pension. We can call it whatever we want. It's paid, they receive a 1099-R at the end of the year, just like everyone else who gets a pension or other retirement income.
30 seconds.
Oh my goodness. Okay. So it is the same. There's not a reason to treat it differently. Are we going to start carving out teachers, firefighters, 1,000 different retirement plans that are different? We shouldn't be doing that. Finally, alimony. First, there is already language. Backing up. Disposable retirement pay, the part that revises that provision. There is language in the Uniformed Services Former Spouses Protection Act that defines disposable retirement pay. So you are going to run into a preemption issue there. And on alimony, the same thing. Why is this benefit different than other benefits? Why is this one that gets carved out? If we carve it out completely, do we have a very low income spouse who's now paying someone who's getting a large amount of retirement pay and VA disability? Are we having them pay alimony to that person because that's how the formula ends up
Thank
working?
you. Will
It's
you
not
take
fair.
questions?
I will happily take questions.
Representative Raymond.
Thank you, Madam Chairman, and thank you for taking my question. So I have a couple of technical questions. My first is regarding the USFSPA definition, because you said there might be an issue there.
Yes.
Can you explain that a little bit more in depth?
Sure. And I actually brought a handout that I'll give you. It was just something I wrote back in 2017 after the Howell decision came out. Because the Howell decision basically said when you're dividing up military pay, you can only divide up the disposable retirement income, disposable retired pay. So it talks about disposable retirement pay, and I've got the site here, is the full amount of the retirement less overpayments for prior pay, for recoupments required for law resulting from entitlement to retired pay, deductions as a result of forfeitures. It's got a list of things that are carved out. It includes already any payments for a survivor benefit plan, which is one of the things that they're asking for here. That's already carved out. Mm-hmm. And it already carves out the VA benefits, the disability pay. Okay. So if you're someone who's getting $2,000 a month in retirement pay, and you have a VA disability that makes $500 of that non-taxable, that gets carved out before the division of property. So it's set out, and I'll share. I only brought 10 copies, but I'll share a copy of that as well.
Thank you. And can I ask a follow-up?
Follow-up?
Thank you. My other question was regarding alimony and child support. Mm-hmm. Is disposable military retirement pay considered in cases for alimony or child support?
Yes, it is. And it just as any other ongoing pension income that people might have from some source, whether they're state employees, teachers, firefighters, it's exact same way. Now, if it's been divided for those purposes, if we're dividing it, say it's a long-term marriage and there's a 50-50 division, it's being considered on both sides of that calculation. So for the lower paying spouse, it is part of their income for the purposes of calculating that out as well.
Okay, thank you.
Yep.
Representative Pearson.
Thank you, Madam Chairwoman, and thank you, Councilor. Do you have that Uniformed Services Former Spouse language printed out that we can have? And do you have enough for everyone at this table?
I have 10 copies.
Okay.
So I'm a
But
little bit short. There
there
are
are
more of you
16
here than when I came last year.
There are 16 people.
I understand.
Probably we would all like it.
Yep.
It would help our decision making.
We can get more copies made for anyone who does not receive one.
And I'm happy to email a copy.
That would be perfect.
To one,
Thank
who
you.
should I send that to?
You can send it to the committee.
Okay. I'll email a
It's-
copy of that to the committee, and I
Yes.
can email a copy of the earlier Divorce in the Trenches that kind of gives a big picture overview also.
Perfect, thank you.
Thank you.
Representative Rice.
Thank you, Madam Chair. Thank you for taking my question. In your professional opinion, is this going to create more litigation going in throughout the course of a case?
I think it will probably create more litigation for several reasons, and I appreciate that question because one, the courts are going to have to start looking at, great, so what do we do with everything else? Like if this is carved out, do we do everything else 50-50 and have a really disparate result? Is that going to create a hardship? The alimony statute, for example, right now already ends at full retirement age unless there's a good cause to extend it longer, which is the full, which is really the exception. But now I think you're gonna end up with questions where people are saying, is there good cause that we have to extend this for really long times? Because we've got someone who has lost what really was a benefit they helped their spouse get over a number of years. Even more so, I would argue, in this sort of situation than in other type pensions, because there is that huge sacrifice by the military spouse, whoever that is.
Follow up?
Thank you, Madam Chair. So if, say the other spouse, the spouse that's not military, ends up having a pension at some point, is that military member privy to half of their pension?
Absolutely.
Should they get divorced? Thank you.
Which is, again, part of the disparity. So, one person's got a pension that's getting divided and the military spouse is getting their pro rata share. And then the military spouse is just, keeping their entire pension. Yep.
Representative Georges.
Thank you, Madam Chair. Thank you for taking my question. I just want to learn a little bit about, because where I know divorce always be a problem, and then somebody loses, somebody can gain. But now the divorce came on the time of retirement.
Yep.
What's going to be for that another spouse?
What happens at the time of retirement?
Yeah, in the time
Okay.
of retirement.
So I think I'm going to answer the question. If I don't, let me know. So it depends. Let's assume that we've got someone who's been married for more than 10 years and more than 10 years that overlaps the military time. Because when you get shorter marriages, it's different. They can't get automatic payments. They can still get a payment, but you've got to count on your ex to send you a check every month for the rest of your life. And lots of times that makes more sense to kind of trade that off for something, right? So if the divorce happens at the time of retirement, there's going to be a military pension division order or military pay division order that divides up the pay based on, usually it's 50% of the amount incurred during the marriage. The law was changed a few years ago so that there's I don't know, 10 years ago now. As I get older, a few years ago, it seems further back, but where it also freezes in time at kind of the pay level that the military spouse would have been in at the time of the divorce. It's the frozen pay rule. So it actually, if the divorce happens much later, you don't get the benefit of all the additional years of increased income and time and service bumps. You get it as though the divorce had happened then. But if it's happening at the time of the divorce, there's going to be an order, and half the pay or whatever the percentage of pay that the non-military spouse is entitled to gets paid directly to them. The courts are then going to, if there's a claim for alimony, things like that, look at is either party working. If one person, can they both meet their own needs? Because if you don't need alimony, you don't get alimony. That's what the law says that in New Hampshire. So they're going to look at, is there a need? And then there's a whole formula. We take one person's, we subtract the other person's, and that includes all of the military pay that's being received by either one. And then there's, I think it's 30% currently of the difference is kind of the max, again, based on need. You don't necessarily get the max, you get up to the max. And again, there are certain exceptions. You might have someone who's become profoundly disabled and someone who's making a very, very large amount of money where there's an exception to that, but that's the general process.
Representative Nelson.
Thank you, Madam Chairwoman. Thank you for taking my question.
Thank you.
Is there a law like this in any other of our states?
So I have not done that research, so I can't answer that. I can say that I have never heard of anyone being like, oh God, we're getting ready to get divorced. I'm going to move to West Virginia because then I'll get to keep my retirement. And as someone pointed out, the federal law says it can be divided up to 50%, no more than that, based on what its specific state allows.
Seeing no more questions, thank you very much for your time and expertise.
Absolutely. And I will email that out, and I'm happy to answer additional questions if they come up in the process.
If you could just send the 10 copies you have down, we would appreciate that as well.
I will do that.
Thank you, ma'am.
All for your time and for the questions.
The next card I have is Roberta Grady.
Thank you, Madam Chair and members of the committee.
You're welcome. You'll have 3 minutes.
Thank you. My name is Roberta Grady. I'm a resident of Hooksett, and I am the spouse of an Air Force veteran, and I'm not a legal expert, but I'm here to tell you about what it's like to be a military spouse, because while I think you probably have a good idea of what it's like to be a military member, you probably don't have a lot of experience as military spouses, but I do. In the 17 years that I spent following a military member around the world, I made 7 moves. Each time I had to reinvent myself for a new career. I had 5 different career fields, not jobs, 5 different career fields with 17 different jobs. And it wasn't because I couldn't hold a job. It was because some of those jobs were temporary jobs or part-time jobs, and I needed a full-time job. Only once was I afforded the opportunity to have a pension, but because I had to move quickly, I wasn't vested. We live, that's me as a military spouse, and I'm older, but there are plenty of younger military spouses. And if you don't know much about them, again, Syracuse University in 2025 published a paper about military spouses. The average active duty military spouse is female, 34.9 years old, has some college or bachelor's degree, is more than likely to have children in the home. She is 4 times less likely to be employed and makes about 42% less than her civilian colleagues. That's important because it means that we don't get to accrue our own personal wealth. We live in places you've probably never heard of or would never visit. We live off base, overseas. We have apartments that have ovens that are too small to roast a chicken, never mind a Thanksgiving turkey. Sometimes we deal with water rationing on remote islands. We live on posts that have terrorist attacks, and we have to find, once again, as we move, a place to be. The military member moves, they have a job. We have to find one. And sometimes those jobs don't exist, or they belong only to the people who are their permanent party. Maybe you're a retail clerk and Walmart doesn't want to hire someone who's only going to be there for a few years. Or maybe you're a dentist and you move to Japan and you don't speak Japanese and you can't get a license there, and all the dentists on base are military members. Military members certainly sacrifice a lot, and they go on deployments, and they miss birthdays and holidays and graduations, and military spouses spend those times alone.
30 seconds.
We live in fear of the time that a staff car might pull up in our driveway with a knock on the door that says the member is not coming back. The military recognizes the value of family and readiness and retention issues, and the Federal Former Spouses Act allows a judge to determine if it is fair and equitable to give a spouse a portion of that pay, just like civilian spouses do. Service members sacrifice a lot, and military spouses do too. And I hope you'll take that into consideration as you make your votes today. Please don't vote to tell them that their sacrifice does not matter. Thank you.
Question, will you take questions?
Yes, ma'am.
Representative Levesque.
I just wanted to thank you for your service. My dad was in the Air Force. My mom was on base. I just know there's a lot of sacrifice when it comes to being a military spouse, so thank you.
Thank you, Representative Levesque.
Seeing no further questions, thank you for your time.
Thank you.
The next person I'll call on is Representative Michael Moffett.
Thank you, ma'am. I'll try to use these 3 minutes in the best way. Also, I'm sorry for delivering those pink cards early. I thought the previous hearing had been dismissed, so sorry about that. So for the record, I'm Representative Mike Moffett, representing Merrimack District 4, beautiful towns of Canterbury and Loudon. I also chair the House Committee on State Federal Relations and Veterans Affairs. And I'm proud to be a co-sponsor of this worthy bipartisan measure, and I'll offer a few important remarks. By the way, I'm also less stupid, just like than I was last term, like Representative Maggiore. So he started to clarify some of the points, and I'll try to do that as well. As a veteran, and many veterans I've been in touch with on this, see this as a very pro-veteran measure, as you've heard and as you will hear. And the notion that spouses are victims of this type of initiative, I think is a canard. Now, I've already shared a lot of information with the committee electronically, and by design, all the personal examples I gave are of women, former military, women spouses. So you please need to understand this is not a gender thing. There are females on both sides of this issue. I also want to point out this time around, I made it a point to attend an SVAC meeting with Colonel Dan Stone, from whom you'll hear shortly, who has some great personal experience with this. And at the SVAC is State Veterans Advisory
30
Committee.
seconds.
And so Colonel Stone spoke there, and the membership of SVAC overwhelmingly, almost unanimously almost, said they want to follow this and not take a position against it. So that's important. So considerable information has been and will be shared with the committee in this measure. And different attorneys and lawyers will have varying perspectives on this, but please know this bill reflects first-rate legal advice. Lawyers have been involved with the language. Representative Nelson had a great question. And as a chair, it's a question I always ask in my committees as to what are other states doing? Are there precedents out there? Have other places done the due diligence? And yes, they have. Latest example is Puerto Rico. This exact measure, almost exact measure, is in law in Puerto Rico to great effect. So that is important. That's a great question. And the answer is yes, it has been, it has moved forward elsewhere, and it's being looked at elsewhere as well.
Thank you. Will you take questions?
Yes, I will if there are.
Representative Wright?
Thank you, Madam Chair. Thank you so much for your testimony, and thanks for taking my question. I just need to know how you would respond to the previous person that testified who, when a spouse has given up their life, traveling everywhere, why they would not be entitled to a portion of this when then they have nothing for themselves. They too have supported that veteran, and I'm a huge supporter of veterans. My dad was a veteran. I was married to a man in the Air Force. I didn't want his money, but you know, how do you look a wife in the face that has given her life to supporting a spouse in the military, or a husband for that matter, and say, yeah, but you don't get this, you're on your own?
Thank you for that, ma'am. Representative, you specifically used the term wife, and then you kind of corrected yourself. As I already did try to address that, this is about fairness and justice, frankly, and there is so much injustice of which you are somewhat aware of in terms of courts not doing right by veterans, male or female. And again, I've already pointed out that in what I've shared with you was all the examples I gave were female examples of people who are victims of the injustice as has flowed from this 1982 Federal Act. It's too late to do anything about what has happened in the past. But by passing HB 1263, that would allow the courts a bit more discretion to better treat veterans and spouses and former veterans and former spouses in their families in the future. So this, if it moves forward, will, as I just said, will allow some discretion to the courts to do things more fairly and more justly that they have not been doing in the past.
Thank you. Before I take the follow-up from Representative Rice, I'm going to recess this hearing for right now because it is after 11 o'clock. And the next hearing was scheduled for 11 on House Bill 1378. I'm going to open House Bill 1378, and I am going to recess House Bill 1378 until we finish with House Bill 1263, which I will reopen at this time and allow Representative Rice her follow-up.
Thank you, Madam Chair. Thank you for taking my follow-up. So then you're saying, so are you saying that this bill just allows judges the discretion they need, that if a woman was married for 47 years to someone, they end up getting divorced, then that judge could still use that money to total out a settlement?
Thank you for the question. And again, as Representative Maggiore said, there'll be a couple of folks following who are more specifically better able to answer that question. But this does go to the point that Representative Maggiore, the prime sponsor, made about the most important distinction here is the notion of retirement pay being property, or retirement, whatever you want to call it, being property. That distinction, which other places have already addressed, is what we think needs to be addressed here. If we can stop looking at retirement pay as property, that enables judges to be more fair.
Thank you. Representative Pearson and then Representative Love.
Thank you, Madam Chairman, and thank you, Representative, for taking my question. I think your time was up as you were starting to answer a question on what other states, you mentioned the Commonwealth of Puerto Rico, but I was looking for a number of states that have something in law that's very much like this that then we could look up and read for ourselves. What states?
I can't give you a list of exactly what states have. I want to be very careful about that because I know different states, obviously, in our federal system do different things, different ways at different times. I did specifically mention Puerto Rico because for a fact that definitely, this measure is definitely in law there. Versions of this in other places, we could research that. But my point is that this has passed elsewhere and is being looked at, versions of this elsewhere as well.
Follow up?
Follow-up.
Follow-up, would you believe that would be very helpful to me before we exec the bill?
Yes, it would, Representative. Like I said earlier, as a chair, that's a question I always ask, and that's why I appreciated Representative Nelson's question on that. It's very important. If some other state has already done, or Commonwealth has done due diligence on this, then that matters a lot, I think, yes.
Thank you, sir.
Representative Love.
Thank you, Madam Chair. Thanks for taking my question. We've heard a lot about military spouses. When someone joins the military, they've pretty much signed their name to a piece of paper saying they are going to sacrifice for the love of country. And if a spouse marries into that, aren't they doing the same? And where is the compensation due? I guess is the word, the phrase I might be looking for. Compensation due for the sacrifice when everybody's sacrificing.
Thank you for that, and it's a very important point. And one of the examples that I did share with the committee earlier electronically was of a woman, an Air Force enlisted woman who retired, and her husband. If you read what I sent to you, this is one of many examples. Her husband was not a very good husband, and they divorced. And he went on to get a great job in real estate, making $100,000 a year. And so she had custody of their child. And she had, because of the way this, the 1982 law has forced some courts to respond, this woman, this retired Air Force woman with a full custody of the child, has to give this guy who's making $100,000 a year or whatever, her limited pension. That is the type of example that is ubiquitous everywhere, and that's what we're looking at here. And again, if anything from my brief testimony that you can draw from this is contrary to some of the things you have heard or may hear, it's not a gender thing, it's a fairness thing, if you're tracking me. So thank you for that question.
Seeing no further questions, thank you very much, sir.
Thank you, ma'am.
Next, I'll call on Representative Louis Juris.
Good morning. Lou Juris here from Nashua. I'm one of the reps in Ward 7. And thank you for having me here today. Thank you for your time. And so I think this bill, HB 1263, as relates to military retirement, it brings a level of equity and fairness to a divorce in the military sense. This makes sure that the military spouse still receives alimony. They're still, especially in a 10-year marriage, still gets a division of assets, child support, and time with children. And that goes both ways. So just briefly, when the divorce petition happens, things, there's a scramble. Children have to go to a different home. Usually the houses get divided, as was mentioned in a previous bill. So there's some stress there. There could be some chaos, etc. Then you go through a discovery phase where you have to trade your information, such as pay, such as assets, expenses, etc. And the forms are pretty detailed. And you imagine if you're a military member on a ship or on a base somewhere. And again, we know that the families who are the spouses who are at home, they could be on base or they could be on stateside or whatever. It does bring a level of chaos, especially if that service member is overseas and is about to be, that could go to war at any time. So upon that, you begin to do a parenting plan. The parents, the children are now in a temporary parenting plan. The court wants to see that, so that there's time that's split between the two households. That's if the military member is at the base. They could still have that kind of time. And then you go to asset separation. So, let's say a checkbook. Checkbook's divided 50-50. If it's a 10-year marriage, it's divided 50-50. 401k or 457B plan. If one party has $100,000 in it and the other party has $50,000 in it, then $25,000's got to go to the party that's got the $50,000 in the 401k. Alimony. Is there alimony? Do you qualify for it, as mentioned before? Well, you set up an alimony. You set up a plan, and it goes on for maybe 5 years or 10 years or less, depending on what it's agreed to or what you negotiate. Now, when it comes down to the military retirement, if it's been 10 years, that gets partitioned out.
30 seconds.
And that gets partitioned out, and usually with the Hodgkins rule, and that payment comes ACH usually, and it comes every month, and from that point forward, it just continues. It doesn't stop, and that's what 1263 does here. It still allows alimony. It doesn't include the military retirement pay. It still allows alimony, but that has to be negotiated. It does not allow for a continuous payment to a former spouse. And
thank you, time.
You got it. Okay. Thank you. Any questions?
Representative Raymond.
Thank you, Madam Chairman. Thank you for taking my question. And I don't know if you know the answer to this, but I'm going to ask you anyways because it occurred to me while you were speaking. Can these the divorce decrees regarding any pensions, but also the military pay, be changed? Because you mentioned child support, and I know child support can be changed if there's a change in circumstances. Can the other things be changed if there's a change in circumstances?
If the payor, who is, let's say, paying 40% of the military, of the marital portion, if something happens to the say the foreign military member, they're disabled, they cannot work, they cannot do their 40-hour job, something happens, emotionally maybe something happens, PTSD happens, suddenly their income changes, then you can go petition the court to get a change in the pension, in the military pay or the pension for that matter. You can go petition the court, but that's going to require sort of like the discovery phase. You're going to have to obtain your attorney or maybe try to do it yourself and go back through the process to ask for an adjustment to your pension. Otherwise, like mentioned before, it just goes on, regardless of how much the other party makes. It just continues. And this is what HB 1263 does. It makes that adjustment. It makes that, I hear a court of equity, the family law court, a court of equity. It brings that equity into balance when it comes time for military retirement pay.
Thank you.
Sure thing.
Representative Pearson.
Thank you, Madam Chairman. Thank you, Representative, for taking my question. We
Yeah.
heard some language around the table here about the wife, and I'm going to do it just in that way. The wife's sacrifice when she marries a military man. Well, let's say the military man retires and he gets ongoing whatever, money.
Correct.
And the married spouse shares in it because they're married. He used to be in and she is still with him. And they sacrifice together. She had signed up for that. But here's the clinker. If they divorce, and because divorce is now pretty much universally no fault, she might be divorced against her will, and she didn't sign up for that. Now what?
You got petitioned. You got petitioned to be divorced. Essentially it means you're getting sued. So you didn't sign up to get divorced, correct?
Correct.
We understand that. And there's a lot of examples like that. So then, as it relates to military retirement pay, they're going to calculate that military retirement pay based on the amount of months you were married with the amount of months the military member was in service. And therefore, unless otherwise negotiated, that military, upon the separation of the family unit, upon the separation of the assets, that portion of the military retirement pay will go to the spouse. Will go to the spouse, and it will go on in perpetuity. So correct, you didn't sign up for this. So I didn't want this to happen. That's not my fault. It doesn't matter. When those things, and especially if it comes down to 50-50, this is how it's going to be separated unless it's otherwise negotiated. And why would somebody negotiate a way out of almost a 50% portion of somebody else's pay? And you could, there could be other things in the mix that you would want instead of maybe that amount of money for the rest of your life per month. There are things you could, but typically that's not the case. And as mentioned before, you got somebody selling real estate, making who knows how much, still getting a portion of that person's military retirement.
Thank you, sir, for your answer.
You're welcome.
Representative Love.
Thank you, Madam Chair. Thanks for taking my question. Couldn't it be just as easily a flip of that circumstance we were just talking about, where the military guy comes home and his wife says, I want to divorce him out of here? Where does that go?
That's correct.
He didn't sign up for that end of the deal either.
That's correct. And I mentioned that earlier in the talk. You're overseas, you're on the ship, you're on the Air Force base. You get the petition. Now you're scrambling because they have to serve you the petition. The military cops have to come and serve it. So how do you have to fight that battle too while you're about to fight a real battle, if you will. So yes, that can happen. It can happen during the service. And then, of course, that military pay would be divided, and you would get that portion after the military person completes their service, or if they're back stateside and they've started taking the military pay, then yes, you would go through the process then. And that's described the whole thing with the discovery phase and all that, parenting plan, and then the division of the assets. And again, if you don't negotiate, you get the 50% of the marital portion for eternity.
Representative Miller.
Thank you, Madam Chairwoman. Thank you for taking my question. we've heard a lot about trying to make this equitable, making things equal and fair. And I'm curious, as I read through the text of this bill, we have the definition of gross income, RSA 458-19, paragraph 5V, and all of these different things. And we're taking just one thing and excluding it. And it strikes me as that doesn't seem particularly fair, right? It's if it's actually fair, shouldn't we be considering the full picture, not a partial picture? How is it equitable if we're not considering everything?
So the military retirement pay is being removed from the assets. That's being removed. That means that the military retirement pay stays with the military member. But what it also means is the military retired spouse is eligible for those rest of those assets to be separated. For instance, a home, for instance, the stocks, the checkbooks, the 401ks. And it also means they're eligible for the alimony. They're still eligible for alimony as that alimony is defined in that situation, or it can simply be asked for. And it'll last for whatever, 10 years or up till the retirement or whatever is negotiated for.
Thank you. I just want to be very clear. I'm reading this. We are in the definitions of alimony, and it is saying that disposable military retirement pay is explicitly excluded from any calculations if this goes through. And you're saying it's going to be part of the separation, part of the calculations, and this bill is saying no, it's not. And
Right.
I'm very confused by how you can make that claim.
So you're taking the military pay out. That military retirement pay stays with the retired military member. That does not mean that retired military member is not required to pay or is not required to negotiate or per whatever the attorneys negotiate, whatever the mediators negotiate, whatever you want, the other party wants, they're still eligible for alimony. Alimony has to be come up with. That alimony still has to happen every month if it's so ordered. How those monies are received to get the alimony? Well, potentially you could use your military pay. It may not be enough. You may have to go get a job or a career, a second career, to pay for that alimony that you're required to pay.
Thank you.
You're welcome.
The next card I have is Deborah Childs. Thank you and welcome.
Thank you,
You have
Madam
3
Chair.
minutes.
Thank you, Madam Chair and honorable committee members. My name is Deborah Childs, and I'm here in strong support of HB 1263. I'm the executive director of Time to Put Kids First, and through that work, I can tell you this issue is not theoretical. I've heard from parents who served their country for decades and now find themselves unable to meet basic living expenses. Just this past weekend, I spoke with a 22-year Army veteran. His retirement was cut 40% because a judge counted waived disability pay as available. This man, who served his country with honor, can't afford to keep a roof over his head. Military retirement is governed by federal law, which already draws clear distinctions between what portion of retired pay is considered disposable and what portion is legally protected. New Hampshire law, however, does not clearly reflect those distinctions. As a result, military retirement is often treated the same as a civilian pension, even though the structure, the legal limits, and the federal rules are fundamentally different. Our courts are left trying to apply civilian pension rules to a military system that simply doesn't operate in the same way. The result is inconsistent rulings and, too often, support orders based on income that is not even available. HB 1263 fixes that. It aligns New Hampshire law with the way military retirement pay actually works under federal law. It clearly defines what disposable military retirement pay means and establishes predictable rules for how alimony sourced from that pay is handled when a service member reaches retirement, and it applies the same rules to everyone, men and women. Judges will still retain authority to order and modify alimony. Courts will still be able to respond to real financial need. This bill does not favor the sacrifice of veterans over the sacrifice of former spouses. It simply ensures support decisions are based on income that actually exists and changes how this pay is factored into the equation so judges can make decisions on an individual basis instead of automatic. We often say that we support our veterans. We thank them for their service and applaud their sacrifice. Gratitude should be more than words. How do we truly thank someone who missed birthdays, holidays, and sacrificed precious time with their children, who accepted danger deployments and permanent disruption to their families so the rest of us could live safely? We thank them by ensuring they are protected as they protected us, and that our legal system treats their retirement and them with fairness, respect, and dignity. HB 1263 is a small but meaningful step in doing exactly that, so please vote yes on HB 1263, and let's protect those who protected us. Thank you.
Representative Georges, do you have a question?
Thank you, Madam Chair. Thank you for taking my question. I hear a lot. And myself, I can say, because this is the problem, like you said, we're going to thank them because for the sacrifice. Those spouses too, they sacrifice, okay? I just going to just say something because myself, I sacrificed my life. My husband be in an accident. I take care of. The doctor told me to stay home. This is a sacrifice. But when he becomes stand up, when he becomes strong, he go ask a divorce. And what was my problem? And I thank God if I didn't go back to school myself. I start to think the way she started to act and say, I need to go back to school. This is what I become today, who I am. But those women too, they sacrifice, I think so. One said, how? They're going country to country. You are dentist, you go to China, you cannot do anything.
And your
You
question,
go
madam?
This is what I'm sorry, Madam Chair, but because I want to just come in a problem, we need to think, all of us, for what you think about this woman who sacrificed because to be for the children, to do this, to do that, and then sometimes too, the military was in a car accident in a problem, and she suffered for that. And
Representative, is that a
divorce,
would you believe?
you believe in that divorce? What's it going to be? How are we going to thank all of them? How are you going to thank both people?
Thank you. Any further questions? Representative Pearson.
Thank you, Madam Chairman, and thank you for taking my question, Dr. Childs. Is the judicial discretion, because situations differ and cases differ, which I believe you eloquently spoke to, rather than following rigid, fixed rules, a good principle for other issues about the family, such as we see often in family court?
Thank you for the question, Representative. I'm not generally here providing testimony in support of judicial discretion, as you know. However, yes, this will allow judges to take everything into consideration. This retirement won't be considered gross income and marital property, but it can be considered, and judges still have the ability to make decisions on alimony. And it does not impact child support, which I did want to speak to briefly. Somebody had asked that question. It does not impact child support, which is under 458, RSA 458. But since it changes the gross calculation, it does, it can impact what somebody has financially, but judges can still respond to real financial need. Right now, they're not just asking for money, they're taking into consideration more money than veterans and military members currently have, as in the example that I gave where it was waived disability pay was money that the military member did not have, but it was included in the calculation.
Thank you, Dr. Charles.
Representative Levesque.
Thank you, Madam Chair. It's more of a question for you and the researcher. Could we get a copy of the UCMJ where it deals with alimony portion of it?
I will ask our committee researcher to find that and email it to us. Can you do that for us? Thank you kindly. Can you hook up with our researcher and give her exactly the information you want her to research? Thank you. Any further questions for Ms. Child? Thank you very much for your testimony.
Okay, and I will provide my full testimony, and I'll also list the other states that have similar legislation, especially Puerto Rico, where it's essentially the same, and there's actually data on the success of implementing this in Puerto Rico.
Thank you very much.
Okay, thank you so
We
much.
appreciate that. The next card I have is Lovey White. Lurvy White. I'm sorry, I'm mispronouncing your name, sir.
Sorry, Larry.
Larry White. Thank you, Mr. White. You'll have 3 minutes.
Thank you, Madam Chairman, ladies and gentlemen, members of the committee. I, in fact, am a retired Air Force officer in the rank of major. I uploaded all my background in this. For the short part of this, I am an expert in high technology warfare, and I am recalled. The form that sends me to the civilian world says you are available for recall if we desire. I have no choice in the matter. I'm also a law school graduate. I'm not a New Hampshire lawyer. I practiced overseas for many years. However, I have written a peer-reviewed article at UFISPA. I've authored the U.S. Supreme Court amici briefs in this, and one for Arizona, where Arizona accepted my position on this and repeated it in their decision. I've never lived in New Hampshire. I lived in Michigan. I apologize for my appearance. I drove 18 hours to be here today because of the weather conditions. Okay, lost all my flights. This is how important it is to me. I can address many of your issues. Ma'am, I feel for you. I completely feel for you because the situation you outlined in both ways applies to me. My ex-wife had failed from university when we met. I had prepared to be a military officer since the age I was 10. Okay? When we met, we married shortly after I was commissioned. She divorced me as soon as I filed for retirement. My experience is that more military spouses, former spouses, divorce than the military member. She had not worked outside the home at all. She eventually became qualified as a teacher with my support. She spent 4 years away from the marriage, away from my assignments, away from supporting me, so that she could obtain those degrees. That she turned into working for the state of New Hampshire as a teacher. She has now earned a pension, a full pension, from her teaching job. I'm 67 years old. I'm on full retirement age. No one has stopped this money being taken from me. This is my money. This is what I earned. In high technology warfare and fighters, my back hurts every day because of the G-forces that I experienced every day flying. She wasn't there. Okay. Now, she makes 60% more than I do because of the money being taken away from me. I've tried to address some of the issues that have come up here. As I said, I've uploaded my testimony to this. The states expect the Congress expected the states to handle these equitably. I have never been able to argue before a judge because labeling the military retirement as pension or as property prevents it from ever being addressed. They take a cookie cutter approach, 50%, bam, it's done. Because it was almost exactly aligned with the marriage with the dates of my service, I pay 49% now. Once you total that up over 24 years, that's more than $400,000. I testified before this
30
committee,
seconds.
before this committee last year. Since then, that's $24,000 more that's been paid. When does it stop? Okay. You can compensate this by 1263. We labeling this as essentially as income. The judge is able to take that into account because the law in New Hampshire details how alimony is to be calculated. I agree, there's circumstances where there should be alimony, but in most cases, there's not. And certainly there should be a time limit on it.
Thank you. Will you take questions?
Yes, ma'am, I will. Thank you very much.
Representative Love.
Thank you, Madam Chair. Thanks for taking my question. You've mentioned that there's stipulations that go along with this money you get from the government. We won't call it a pension or anything else, but you get money from the government, and the stipulations being recall. You can't work for a foreign government. You can't do this. You can't do that. You have to do this. You have to do that. Isn't that like a job in itself?
Well, it is, and that's what they're doing. Lawyers are familiar with retainer. We know what retainers are. It is retainer. I am retained from doing anything else, and I even hate considering the possibility, but I have skills that would be of value to people that we do not like. But thank you for reminding me of it. When I worked in Turkey, I worked for a Turkish state university. The Air Force required me to secure their permission to do that, to continue to receive my money. I do know of after the Cold War, there was a U.S. Army colonel, because he was, I think it was Latvian extraction or Estonian, worked as the Estonian defense minister. He lost all of his military retirement retention pay during the time he was working for a foreign government. So we are very much limited on this. My life in Turkey would have been much easier if I could have taken Turkish citizenship. I am not. Anything that would bar me from serving in the future in this, and I think if you look at the discussions about Senator Kelly, these are very much applicable with regards to this. It's not so much what you're doing now or in the past, it's your availability to serve in the future.
Thank you. Follow up?
Thank you for your question, sir.
Do you know, I've asked for follow-up, would you take a follow-up first? I'll ask you.
I'm sorry?
Would you take a follow-up question?
Oh, absolutely, sir. Thank you.
Do you know if your ex-wife has any stipulations on her pension, whether she has to go back and teach or?
As far as I know, not she can't be recalled. But like I said, she gained all those skills. Her bachelor's she never finished, a master's, as well as when she got hired, but she was specifically hired because she had the overseas experience. And as you detailed in my statement, she spent the vast majority of it with my consent, okay, because we are partners, looking after our children and traveling. How many of you have been to London, Paris, Milan, Vienna, multiple times? She had a great time. She played an instrument school. She played with a German band. She's still in contact with those people. She wasn't sitting at home doing nothing. And most of the testimony you heard with regards to military wives applies, or spouses applies to the 1950s. We never had a very, very small kitchen. We had a nice home, okay? We moved, but very many, or a number of my academy classmates who went into business, they move every 2 to 3 years too, all right? I believe firmly that the alimony system is quite capable of dealing with the individual things. I never was able to argue these issues because it's property.
Thank you.
Thank you, sir.
Thank you for the question.
Seeing no further questions, thank you very much.
Thank you very much,
your
ma'am, for the opportunity to speak.
testimony. The next card I have is Frank Kurland. You two will have 3 minutes, sir.
My name is Frank Curlin. I'm retired Navy, 21 years. We were married 17 out of the 21 years that I was in the service. My ex-wife received 43% of the military retirement. That was on a condition because I chose to fight custody for our kids. She made it perfectly clear that if I gave up custody, she would give my retirement. I made the statement that my kids, excuse me, are not for sale. I stand before you today as a constituent of the Granite State to support House Bill 1263. My purpose is to request your consideration to listen and share an ongoing mission. There's over 300,000 retirees affected by the federal law, 10 U.S. Code 1408, payment of retired or retainer pay in compliance with court orders. For the last 40 years, literally picking the pockets of veterans for life. I've been paying my former spouse longer than we were actually married. She has since remarried and divorced another military veteran, retired after 6 years, and was denied by the court any portion of the retiree's retiree pay due to a prenup. That was the only reason that the judge wasn't going to give her the cash. Okay? And she's currently in another long-term relationship. The Uniformed Services former spouse was intended to protect the former spouse by allowing the state to award a portion of the 50% of a retiree's military retainer pay for life when a couple divorced. The law does not mandate a division of MRP, military retirement pay. It only allows the state to apply a division, which the courts have interpreted as must-will. They're doing it all the time. The legislation was able to do this by defining Fifth Amendment and mislabeling retainer pay as property, and so it goes on. In support of my request, I'll present you a presentation which I gave some handouts here. One from Karen Throckmorton, who was married to a retired colonel. He passed away at 95. He was paying his ex-wife for 43 years, and it only terminated when he died. His last wish was, I just want one full paycheck before I pass. Obviously, that didn't happen. The horrifying result, military service centers are subject to a greater division upon divorce than the civilian counterpart. New Hampshire alimony ends on cohabitation, remarriage, monthly maintenance is capped, and there's a time limit. Military retirement goes on and on forever. The only time it reverts back to the service member is if my ex-spouse dies.
30 seconds.
Our veteran solution, amend the New Hampshire family laws to disallow any division of military retirement pay. It's a non-contributory retirement plan or any disability pay. I gave a handout where the GAO gave an explicit definition, a request from another military retirement about a pension. And they said it is not a pension, it does not accrue, it doesn't fit the stipulation of a quadro, it's mislabeled. All right, thank you for your time. Take any questions.
Thank you. Questions? Representative Nelson?
Thank you, Madam Chairwoman. Thanks, well, for taking my question. Did you, that paper that you just held up, did you, is that a handout for us
It's in the
also?
packet. It should be in the packet, yes, ma'am.
Okay, great. I'm the
Yeah.
clerk, so I have to just make sure I have all the correct paperwork. Thank you.
And
Seeing no further questions, thank you very much for your time and testimony, sir.
hey, thank you for your time.
The next card I have is Daniel Stone.
Good morning, and thank you, Madam Chair and Committee, for hearing me. I'm Colonel Daniel Stone, United States Air Force, retired. I've served over 30 years to my country. I served 44 months in combat, 24 of those months on the ground in Afghanistan doing counterinsurgency combat. While I was actually deployed in combat, it's the time when my wife divorced me. First thing I want to come off and say is that military retainer pay is pay for reduced service. It is not a pension. You qualify only for it if you meet certain obligations. It's only paid to you as pay because you have to do a service to the United States government. It has restrictions. Very interesting, the United States Supreme Court and actually the New Hampshire Supreme Court twice have ruled that military retainer pay is pay and is not property. Those were both overcome by legislatures, very hurriedly legislation, and predated them to counter those. Also interesting to note, as the U.S. federal tax courts have consistently ruled that military retainer pay is pay and is alimony irregardless of what a state says it is. This bill is only pushing out to say that military retainer pay is pay and not property. One of the questions asked earlier said, well, what if a person makes $100,000 as the ex-spouse to you? Can you get that changed so you don't have to pay it? No, you cannot, because it's property and judges in the state will not open up a property settlement because they say it's property and it cannot be changed. The USFSPA says that states may treat it as property, but it inherently is not property. So we do have some misconceptions about the military divorces, and one of those consistently pushed around is to say, well, you know, it is, like I mentioned earlier, that it's pay or it's a pension. It clearly is not a pension. It's an unequal share of burden. I never saw my spouse in combat with me, whether in the air or on the ground. I never saw her having to deal with both the physical and emotional scars of war that I'll carry for the rest of my life. All right? I'm restricted about the jobs I can take when I leave the military. I'm restricted about, I can be recalled to active duty. I'm still under the Uniform Code of Military Justice. I can be punished for civilian crimes if I were to commit them as a civilian. This is a very clear, easy example. You look at Senator Mark Kelly. He's going to potentially be punished for that, right? I never see a spouse doing that. We talk about that, yes, they do sacrifice, but again, this is a pay, and can be handled through alimony, not as a property settlement. The story that spouses are always the victims is absolutely not true. My spouse got to move all the way around the world with me, had jobs while I was overseas, got to take vacations, actually took vacations while I was actually in combat. I didn't get to do any of those things. As you heard, other people, they get jobs because of the experiences they have out there. We mustn't forget about 18% of the U.S. military today is female. Also, jobs today. People are moving around every couple of years in normal jobs. Jobs are no longer geographically required. Spouses have jobs all over the world working all kinds of different times. We've got to take ourselves out of the 1950s and stop thinking that spouses are nothing more than victims, right? I'll even tell you that spouses harm careers. While I was in the military, my spouse actually damaged my career. She had a pissing contest with a commander of mine's spouse. Well, that person, when I later on moved to another job, I was in line to take squadron command. He became my wing commander. Guess what happened immediately after that? I was no longer going to be that squadron commander.
30
After we got
seconds.
divorced, she decided to call my commander and tell lies about me. I had to take her to court, prove it was wrong, but guess what? It destroyed my military career. I no longer advanced, and I lost by name request to become a commander. I went hit on it's not a pension. By federal law, DOD financial management regulations say there's retired pay and it's not a pension. It's a statutory entitlement computed at the time of service a member retires. Okay? We keep on talking about a quadro. A quadro is not required by this because it's not a pension. It does not meet under the Section 401A of the Internal Revenue Code. Okay? We have a lot of misconceptions. This can all be handled through alimony at the judge's discretion. If you leave it as property, it is non-changeable. It is nothing can be done about, and therefore that is the damage to the military member.
Thank you.
I'm open to questions if you have any.
Representative Miller.
Thank you, Madam Chairwoman. Definitely double-sided name tags for the substitutes. Sorry about that. And thank you for taking my question. You suggested a couple times in your testimony there that we should just handle this through alimony and it shouldn't be considered property. And I keep reading this bill and we're changing the definition of income vis-a-vis as it relates to alimony. And I don't understand, how you square that circle. How are we reconciling that this is about saying this money does not apply to your gross income for the definition and calculations of alimony if we're supposed to fix this through alimony? If it's supposed to be fixed that way, shouldn't this be included? And why are we saying the court cannot do so?
I don't think anyone's saying, thank you for the question. I don't think anyone's saying the court can't do something. I would argue the court can do too much normally. This is used as a pay, and therefore if it's pay, the judge can actually look at it for the terms of alimony.
Representative Rice.
Thank you.
Thank you, Madam Chair. Thank you for taking my question. Are you aware in the bill, it says disposable military retirement pay shall not be considered gross income for the purposes of this chapter? Shall not. It does not say may. It says shall not. So how is that going to be used for alimony?
I would say, again, a judge is going to have to make that decision.
It shall not.
Well, I would argue to you that the U.S. Supreme Court ruled that military retainer pay is the sole party for the former service member.
Thank you.
So in New Hampshire, shall means or shall not means that's it, end of story. If in the bill it said may not, then the judge would have discretion. Are you aware of that?
I'm not a lawyer, ma'am. I'm just someone who's negatively affected by a divorce that I can't do anything about because the system looks at everything of just because it's possible, it automatically gives 50% of my disposable retired pay.
Sorry for your troubles and thank you for your time and efforts coming here today. Seeing no further questions, thank you, sir. The final card I have is Representative Geisen. Thank you for coming here today.
Thank you, Madam Chair, Honorable Committee. So I'll be brief. I am in the retired reserves. That's what they call it when you retire from the military, retired reserves. My salary or retainer pay is just under $3,000 a month. A lot of people don't realize that those are the kinds of numbers that we're talking about. So 40% of that would put my retainer at about $1,600 a month for the rest of my life. One of the concerns that I have, and we can't fix the world here today, is that the military does incentivize marriage in a pretty dangerous way, which is why we have such a high marriage rate so young and such a high divorce rate. But they've also weaponized divorce through systems such as we're talking about now. I've seen this. I've seen a couple stay married so that somebody can stay on the military health insurance and then stay married until 10 years and 3 days to divorce because they knew that they were going to have certain entitlements through divorce court by assuming a portion of the retirement pay, as is the law. So I'm very concerned if we don't pass something like this because I've actually seen this. I've seen this among my soldiers. And when I say that marriage is incentivized, I mean at 18 years old, if you get married, you move out of the barracks into on-base housing, your pay almost doubles. You get allowances for the family. It's not your pay that doubles, it's your non-taxable allowance. And as long as you are married, that continues to be the case. This breeds a toxic issue that we can't address in this room. What we can address is the way we treat the weaponization of divorce in the state of New Hampshire. And so I'm strongly supporting this bill.
Thank you, sir. Any questions? Seeing none, thank you for your time. That's the last card that I have on House Bill 1263. I'll now close the hearing on 1263. I'm going to now come out of recess and open the hearing on House Bill 1378. Thank you. House Bill 1378 is now in progress. Representative Geisen, are you going to introduce the bill, sir? Thank you kindly. You have 3 minutes.
Thank you, Madam Chair, Honorable Committee, Representative Henry Geisen, Hillsborough 29th District, the charming town of Goffstown. It's actually really pretty down there. So I'm introducing House Bill 1378. This bill mirrors one that passed this committee unanimously last year. Unfortunately, it got kind of hung up in the Senate and attached to some other bills by amendment and stalled. The prime complaint that we heard about, the bill allows for parental access to medical records, specifically online records. Most of the records these days are kept online. When you ask for a copy of medical records in person on paper, oftentimes there's a charge, but a lot of times these portals are free access for all clients. There are already redactions that are covered under law. My understanding is the prime complaint was an expense on the system change. I promise you that these insurance agencies and medical facilities can do it. Their automations and computer systems people are talented enough to do it at not the cost that they've been pushing. A digital record is a record, and it's in real time, and it should not be this complicated. So I would suggest that we push this bill through. Thank you.
Thank you very much. Any questions for the representative? Thank you for your time, and thank you for introducing the bill for us. The next card I have is Mara Weston.
Good morning, members of
Thank
the
you,
committee.
madam. You'll have 3 minutes.
Thank you. My name is Maura Weston, and I'm here today on behalf of the New Hampshire Medical Society. The New Hampshire Medical Society certainly recognizes the care and responsibility of parents in raising and caring for their children. We also recognize the medical importance of providing minors between the ages of 12 and 18 access to confidential medical care. We do have concerns about this bill, and I'm here today in opposition to it. One of our concerns is that the bill defines medical records very broadly, including online patient portals and electronic health records, and this has limited exceptions. We don't believe that the portal should be part of the definition of medical records, and the production of a medical record actually requires judgment if our providers are to adhere to privacy laws that currently are on the books to protect our patients and access to care. More broadly, elements of a minor's care, for example, care that might be related to sexual health, once that is captured in a record, would no longer necessarily be protected if this bill were to pass. So even if the care itself might be confidential, the records would then not be. So we do have significant concerns about that. We certainly support effectively balancing the needs of guardians with the needs of minors who need protection and seek confidential care, particularly for mental health, reproductive care, or substance use or sexual care. So for those foregoing reasons, we would like you to recommend this bill in expedient to legislate, and I'm happy to answer questions to the extent that I can.
Representative Rice.
Thank you, Madam Chair. Thank you for being here today and taking my questions. So, I'm sorry, who are you with again?
My name is Maura Weston, and I work with Cornerstone Government Affairs, and I'm here today on behalf of the New Hampshire Medical Society.
So does the New Hampshire Medical Society think that the ages of 12 through 18 are not children?
Thank you for the question. We recognize that minors are, under the age of 18, certainly.
Do they also, follow up, Madam Chair? Do they also believe that it is in the best interest of children to keep secrets from their parents by not availing these parents the ability to view their own child's records for the health care that they are paying for?
Thank you for the question. I'm going to respond to that in a couple of ways. It's my understanding that parents can access records in the traditional format when those records have been appropriately redacted pursuant to both state and federal laws to protect access to care that can be provided confidentially. That's my understanding.
Thank you.
Thank you.
Representative Raymond.
Thank you, Madam Chairman, and thank you for taking my question. My question is about HIPAA. It's been a very long time since I worked for Medicaid, but 20 years ago when I did, there were exceptions to what information parents had the right to access, and some of that was reproductive health, some of that was mental health, and some of that was substance abuse. Is that still the case, and would this bill be in conflict with either HIPAA or other existing federal laws?
I'm not a HIPAA expert. However, my understanding is that, in fact, if this were to pass, it would be in conflict with protections under both HIPAA and state laws.
Thank you.
Representative Rice.
Thank you, Madam Chair. Thank you for taking my question. So are children under the age of 18 signing contracts as what HIPAA would be? Because I have to sign every time I go to the doctors for HIPAA. I don't understand how a child under the age of 18 can sign a contract like that.
I'm not an expert in HIPAA. All I am told is that certain care can be provided confidentially to minors. And that is the limit of my understanding.
Follow up?
Would you agree that it's in the best interest of the children for the parents to be aware of the medical conditions their children are going through to better support them at home, especially if it's a mental health issue or if it's, they're going for birth control. Birth control has a lot of side effects that parents should be made aware of if their children are on that. So I feel like, I'm sorry, go ahead. Would you agree with that?
I'll do my best to answer your question. Thank you. As a mother, I would always hope that healthcare is part of a family conversation. However, I'm here to talk about the legal implications and the policy implications of the bill in front of us, and we believe that it would negatively impact access to care for some of our patients, potentially in conflict with both federal and state law.
Thank you. Representative Georges.
Thank you, Madam Chair. Thank you for taking my question. Okay, is a minor, is a child, okay, under 18, or now she have a problem. If a parent cannot stand, cannot know what is going on with my child, who's responsible to sign everything? Can be in the hospital. Who's going to pay the thing? Is it the parent or the child? Who pay everything for the money? Because is under the parent to support it, to protect it, to do everything. Now, the parent cannot know what is going or to know about the medication or to know what happened because to protect the child. But what's going to be with that child if there is a problem? Who's going to be responsible? The parent or the doctor or I don't know. Who?
I'm not sure that I understand the question. I appreciate you asking it.
Madam, her question is who's going to pay and who's going to be responsible for the child's health care and is it fair that they don't know what their health care issues are, yet they have to pay and be responsible?
So in certain circumstances, I imagine that there are different payors, ultimately as a parent responsible for their minor's care in certain circumstances, perhaps. If they're seeking care through insurance program with a primary care physician, there are lots of ways in which children, minors, may access care. And I understand that your question is, who's responsible for payment. I'm not sure that there's a link legally between payment and access to records.
Follow up?
Yes, follow up. Thank you. Now they can give a medicine that is not right or something that can provoke the problem for the child. How the parents gonna know? Because sometimes because for the medication, what she taking, or even for sexual or something, how parents gonna try to help the child if they don't know what happened to their child?
I appreciate your concerns, and I certainly appreciate the concerns raised by the sponsor. I think I'm simply here to point out that what is being proposed potentially or does conflict with federal and state law, and it puts our providers in a untenable situation of not being able to comply.
Thank you. Representative Pearson.
Thank you, Madam Chairman. Thank you for taking my question. I am part-time CEO of a medical facility. I live with this daily with my staff. I also, in response to both your testimony and in particular, a handout that came around starting, "This bill will silence teens," I question, there are exceptions in this bill. There are exceptions I live with. There are exceptions that say, yes, release the records, but not under these circumstances. how do you respond to that in light of perhaps testimony saying this will harm children or violate confidential communication? I don't see it in the bill.
Thank you for the question. I'm not familiar with the handout that went around. It was not from the Medical Society, so I have not seen that. And I know that there are people who are following me with testimony that can respond more specifically to elements of this bill. I believe the Hospital Association, perhaps Planned Parenthood. I'm not sure who else is following me. But what as we look at this bill, we have concerns, and we believe that certain care can be provided confidentially, and that the definition of medical records is so broad that it would make it difficult for us to comply with the law.
Follow up?
Follow up, except things under state or federal law. I mean, there's some words in here which are not broad.
Our concern primarily rests within the definition of medical records. And as we read the bill, we have concerns about the implementation of it and how it would impact our providers and patients.
Thank you. Representative Nelson.
Thank you, Madam Chairwoman, and thank you for taking my question. I receive from my insurance company explanation of benefits whenever my minor children have medical care. So my question is, what's the legality of the insurance company for providing me with information regarding medical testing and the purpose of the visit? How is that legal, but how is what we've been talking about not legal in terms of the federal laws?
I'm not an insurance expert, and so I really can't opine on the disclosure through insurance explanation of benefits. And it remains my understanding that a parent can access records through the traditional means of obtaining the paper records if those records have been appropriately reviewed and redacted to protect confidential information.
Thank you.
Thank you.
Seeing no other questions, thank you very much for your
Thank you.
time and
I
testimony.
appreciate it.
The next card I have is Kathy Bizarro Thunberg. Thank you. And thank you for submitting your written testimony. It is greatly appreciated, and you'll have 3 minutes.
Thank you. Good afternoon, Madam Chair and members of the committee. For the record, my name is Kathy Bizarro Thunberg. I'm the Executive Vice President, New Hampshire Hospital Association, representing all 26 of our state's community hospitals, as well as all specialty hospitals. The Hospital Association has concerns with House Bill 1378, but I do want to state up front that we completely agree with the general statement of the purpose of the bill. The vast majority of parents absolutely are acting in their child's best interest, already do have access to their child's medical record, and are responsible for providing access to and coordinating medical care. However, the bill as written raises some concerns for our hospital members. Of particular concern, starting on line 9 in the bill, is the inclusion of the words, quote, including records available via online patient portals, end quote. To define a medical record this way creates technology standard that currently cannot be met by many of our hospitals in the state. That's because patient portals should not be considered as part of the definition of medical record in the statute. This bill acknowledges in Section 2A that there are records that are protected under federal and state laws that parents are not able to see without the child's consent. These include substance use treatment, sexually transmitted disease treatment, reproductive health services, and care for emancipated minors. Technology limitations of many hospitals' patient portal systems are not capable of parsing the medical record to redact these protected services in the patient portal. However, hospitals are able to provide a medical record via a digital file or a hard copy in compliance with federal and state regulations, including appropriate redactions, which hospitals do so routinely at no cost to the patient. If this bill moves forward, our members will not be able to comply with both important privacy protections and the mandate under this bill to provide access to a minor's medical record via a patient portal. Therefore, as an unintended consequence, patient portals with this technology limitation will no longer be available to patients. Given these concerns, we're not able to support House Bill 1378. Thank you for the opportunity to share our concerns and happy to answer questions.
Thank you, Representative Rice.
Thank you, Madam Chair. Thank you for being here and taking my question. Could you give me an example of what would be redacted in a medical record for a 12-year-old?
Sure. If they were seen for a sexually transmitted disease, or if they were under substance use treatment, those are the types of things that would have to be redacted under state and federal law.
Follow up?
So you have a child that's having substance use issues and parents are not going to know about it because it's the law for it to be redacted. Yet if they OD in their house and they don't know what's going on, how are they supposed to help that child?
This bill is not talking about what should and should not be removed from parental access. That is already state law and federal law.
Yeah, I'll be changing that. But I follow up.
Follow up.
So you're saying that by having the portal on the phone or the computer that the parent pays for and probably sets that up for them, that parents are already having access to that. So I don't understand what the big deal is.
So what this bill is saying is that because they're trying to define a medical record is also what is available in a portal. A portal is only a portion of a medical record. It does not contain every single page or data element that's available in a medical record. That is something that is kept with the provider or the hospital. A patient portal is a convenience for sharing certain portions of that are defined by that portal. It could be list of medications, it could be appointments, it could be a way to communicate with your provider or test results, things like that. But it's not meant to be the entire medical record, which is why we have concerns with this bill because it is trying to establish that a patient portal should be the entire medical record, and it is not.
I have a lot more to say, but I'll stop there.
Thank you, Madam. Representative Pearson.
Thank you, Madam Chairman. Thank you for taking my question. It's probably a question with a follow-up. Presently, under law, is it the case that with the exceptions of privileged communication, a parent can access physical and electronic records? Is that currently available?
That is correct. Thank you for the
So,
question.
follow-up, is the only concern the online patient portal, because otherwise poor little medical places like my own would have to spend time blacking out things on the portal and go through everybody's portal lest something that is otherwise privileged communication sneak through.
Thank you for the question. That is correct.
Got it. Thank you.
Representative Raymond.
Thank you, Madam Chairman. Thank you for taking my question. So I have kids who are teenagers, and my 17-and-a-half-year-old just had eye surgery at Tufts Medical in Boston in January. And I had to do everything over the phone with them because they don't do a patient portal for 17-year-olds. They just don't do it because he would have to set it up himself. It was a whole thing. So my question is, are there currently, and I found out that Beth Israel doesn't do it either, are there currently any hospitals or providers in New Hampshire that set up a portal for minor children?
There are some that can do that, but it's limited on who can do that based on what they may have for technology or a portal.
Okay, can I ask a follow-up?
Follow up.
So I guess my question is technical then. What is the software difference between what the couple places in New Hampshire have versus what Tufts Medical Center in Boston doesn't have?
Sure. Thank you for the question. For the 26 acute care hospitals, there's probably a dozen or more different types of medical record or electronic health record softwares out there. They're all slightly different in their own ways because of the way that they've been established or the type of hospital that they're serving. This also would pertain to physician practices, which I have no idea how many upteen different types of medical record softwares there could be.
Can I ask one follow-up?
Yes.
Thank
One.
you. If we were to pass this as written, would it give an effective monopoly to the software providers who provide this option? Or would it require an outlay by all of those medical providers that don't have it? Would they be required to buy in to that software?
Thank you for the question. I think the way that we've looked at that is that there could be a possibility of portals being shut off for anyone over the age of 12 because the softwares weren't able to do the proper redactions. So it's a matter of probably less access through a portal than trying to force the hand of others to create software changes. That may happen in the future. It just doesn't happen today. And I think, again, I just want to make sure I'm clear that the concern that we have is the definition of medical record trying to incorporate something that is not a medical record.
Thank you. I have a question if you'll take it. You said that the portal is not a complete medical record. Is that correct?
That is correct.
I'm going to ask for a follow-up of myself. So if that's the case, then is it possible that the redacted information that you're talking about wouldn't be on the portal to begin with? So parents should be able to be on the portal to read what testing, the results of the tests, and so forth, and the medications that the child is on, so that the parent can make sure that it's picked up at the local pharmacy. Is that true?
Thank you for the question. The way that portals are set up is they will take in information from the medical record. So it could be a list of medications, which could include birth control, could include antibiotics, could include, whatever the child is on. Birth control would fall under sexual health type of information, but some of the portals are not sophisticated enough to be able to look at the individual medication level to redact it, which is why if a parent went to a hospital or a physician practice to ask for the full copy of the child's medical record, a professional would sit down and go through that record and do the proper redactions before it is issued.
Thank you. Representative Rice.
Thank you, Madam Chair. Thank you for taking another question. So can you tell me how the 13-year-old gets a prescription, birth control, I don't care what it is, and has a reaction at home? Whose responsibility is that if the parents are not made aware?
Thank you for the question.
I'm changing them.
Representative Pearson essentially answered my question. It is part of the state law that allows for the redaction of that information.
Representative Nelson.
Hi, thank you. Hi, thank you, Madam Chairwoman, and hello. Thank you for taking my question. I guess I'm going to try to ask my question again that I asked before to the prior person. I'm just very confused because, like I said before, through my EOB, I will get information about a visit or, through my pharmacy, information that talks about, what the pharmacy has provided per prescription. So I do get that information that
would be, I guess, redacted in a medical record. So how is it that my EOB that's sent to me how is the insurance company allowed to give me information about those things that I just talked about versus not having access to medical records? Like, where in law does the EOB benefit paperwork, for lack of a better term, be able to disclose private information, but a doctor's office can't?
Thank you for the question. I don't represent insurance companies, so, and I'm not as familiar with their statutes regarding that. So I apologize. That's not something I can readily answer.
Thank you.
Representative Corson.
Thank you, Madam Chair, and thank you for being here to answer these questions.
Sure.
Would you believe that just a few weeks ago, we heard on the House floor that your brain is not fully developed until you're 27, that the frontal lobe doesn't even develop till you're 27. We heard that from the House floor as a way to keep younger people from doing something. How is it that we're giving children prescription drugs that all have side effects? These drugs without a parent's knowledge, and yet we're still asking the parent to pay for these things. How is that right in any way?
Thank you for the question. With all due respect, that is not something that is subject to this bill. This bill is specifically related to access to minors' medical records. So I am not going to opine on, state and federal laws that already protect minors.
Okay, sorry. Well, with that being said, how is it that we still have people fighting against a parent's knowledge when a drug is given to a child, let's say birth control, hormonal birth control, they run the risk of, PID, pelvic inflammatory disease and whatnot. If a parent doesn't know that those things are being taken, how can they watch for side effects?
Again, thank you for the question. I'm not a clinician. I am not here to debate the current state and federal laws that allow minors to have access to these services without parental knowledge. So again, this is something that is already covered in the bill.
Representative Pearson.
Thank you, Madam Chairwoman, and thank you for taking my question. I've been on the phone with my chief medical officer, and what is sent back to me is interesting. We will take the time to redact the paper records for the patient, of the minor patient. We will take the time to redact the electronic records before they go to the parents. Why won't we redact the portals too?
I don't know excuse me, thank you for the question. I don't know what kind of effort, staff time, et cetera, would be needed to be able to support that extra redaction in that software system.
Follow up? And yet you do redact, and you must by law, the paper records. And you do take the time by law to redact the electronic records. Is that not true?
That is upon a request.
Of course it is.
Yes. So we don't do it automatically for every single patient.
And I do not believe you're being asked to do this for every portal either, according to this bill.
If it is, excuse me, thank you for the question. If the bill passes and it equates a portal to a medical record, then that would require portal reviews for every single patient, regardless of requests.
Why? Do you do that for every single paper record, every single electronic record?
Thank you for the question. The redaction happens when a request happens.
Thank you. And you would not have to redact every portal you have.
Thank you.
Whatever question.
Representative Miller.
Thank you very much, Madam Chairwoman, and thank you for taking my question. Given the ad hoc nature of access to portal data, which is to say that anyone can pick it up at any time, and the need for proper professional review rather than automated redaction of documents, can you explain what the workload requirement would be to make sure that that information was redacted before the request came in for any given record?
I thank you for the question. I'm not a medical records professional, but I do represent them, so I'm familiar with a little bit of their work. They handle hundreds of thousands, if not millions, of records statewide. We have over 150,000 inpatients and millions of outpatient records just from a hospital setting. So the amount of work that they would have to go into every single record before it was available to post would be astronomical.
Are there any further questions? Seeing none, thank you very much.
Thank you.
Up next, I'm going to call Matthew McSorley. Correct. Thank you. You'll have 3 minutes, sir.
Good afternoon, committee members. My name is Matthew McSorley. I live in Litchfield. I'm a father of 4. The responsibility parents have to their minor children is awesome, and this bill is needed to ensure that parents have the information they need to make informed decisions for their children. In my own experience, our minor children allowed us to sit in on their doctor appointments even until age 18. Nevertheless, we were denied some critical information in their medical records that we needed to make decisions on their behalf. One of our children, who we later found was autistic, fell into gender ideology. After that child turned 18, against our wishes, our doctor referred that child to a gender clinic. Though at that point we understand we had no legal say in her medical care, we do wonder what information before the 18th birthday would have helped us have critical conversations that might have kept our child from experimental procedures that even the American Medical Association and the American Society of Plastic Surgeons are backing away from now that someone who regrets those gender treatments has won a $2 million malpractice lawsuit in New York State. We as parents have a lifelong relationship with and commitment to our kids. No medical or mental health personnel has that same commitment. They are service providers who are paid to take care of us. We've seen that the medical and therapeutic professions have been captured by this gender ideology that harmed that young woman in New York State and thousands of others. When medicine becomes infiltrated by activists, parents, children, and families like mine are especially at risk. There's no reason and no data to support the idea that medical and therapeutic personnel have a child's best interest in mind more so than their parents. This bill already allows courts to declare negligent parents unfit to share information. Why should all parents be in the position of proving to doctors that they are not abusive? Since when do parents answer to unrelated medical and therapeutic personnel? When our child starts regretting those gender treatments the professionals moved her towards, it will be us, her family, who will be there to support our child, not the medical professionals, not the therapeutic professionals, and certainly not the activists who would trample on the parent-child relationship through opposition to this bill. The activists will say that parents need to have strong relationships with their children so their kids won't want to keep secrets. Yet here they are testifying in favor of keeping secrets from parents. They are planting in kids' minds the idea that their parents can't be trusted. These activists have an agenda, and it isn't the best interest of children or families. Parents have their kids' best interest in mind. Please vote ought to pass on HB 1378. Thank you.
Thank you very much. Are there any questions? Seeing none, thank you for sharing your story. Up next is Stephen Scare. He's asked for 2 minutes.
Thank you.
Good afternoon, Chair and honorable committee members. I'm here to support this bill. Parents need complete access to their children's records, including electronic records and patient portals, in order to protect them from history's greatest child abuse medical scandal. The American Academy of Pediatrics is captured by transgenderism, an ideology that teaches that a boy's essence or soul can possess a girl's body. This gender identity, not her body as her authentic self, and it must be affirmed socially and medically if necessary to keep her from dying by her own hand. Some doctors are using their private time to affirm children's delusions. Then they emotionally blackmail the parents with unfounded threats of suicide. If parents don't cave, these doctors conspire with the children to begin these treatments the moment they turn 18. In February 2023, in an op-ed, Dartmouth Health pediatric endocrinologist and now vice president of the AAP, Francis Lim Liberty, wrote, "I see a patient whose parent has been refusing to sign consent for gender-affirming hormone therapy for the past 3 years. My biggest fear manifested, would she make it to her 18th birthday, just 3 months away? I worry I won't see her again. I promise her we will start medical affirmation as soon as she turns 18. This is bad medicine. First, there's no such thing as a transgender child. I am not a doctor, but I defy any medical professional to tell me what a girl is, a boy is, a gender identity, or a gender is without circular reasoning or stereotypes. Second, systematic reviews are at the top of the pyramid for medical evidence. Each of the 17 systematic reviews of pediatric gender medicine show there is no good evidence that affirming delusions with pronouns, knives, and chemicals improves mental health or reduces suicide. And they have determined that suicide is extremely rare, even among trans-identifying youth. The AAP promised its own systematic review in 2023, but never delivered. Why not? Please vote ought to pass and help moms and dads.
30 seconds.
Thank you. Protect children from health professionals who have traded medical science for a blind devotion to a cruel and convoluted ideology. Thank you.
Thank you for your testimony. Any questions? Seeing none, thank you very much, sir. The next card I have is Nancy Biederman.
Hi, Nancy
Thank you, ma'am.
Biederman.
You're going to have 3 minutes.
Yes, Nancy Biederman. I am part of the New Hampshire Rare Disease Advisory Council. In fact, I'm doing the governor's office in about 25 minutes for our Rare Disease Proclamation Day. Rare Disease Day happens on February 28th. And just to give you an insight of what happens with a rare disease patient. This is 1.5 years. Where did I get all this? From my child's portal. As a rare disease patient, when you're trying to get diagnosed, you see multiple doctors. They are not all connected. They don't talk to each other. So you're the person, you are the point person. You have to make sure that Dr. A, B, and C knows what Dr. E, F, and G are doing. And yes, my daughter at one point had up to 10 doctors that she was seeing for medical care because every doctor only specializes in one part of the body. And they don't understand or care about a different part. When I ask a doctor, or she asks a doctor now that she's of age, well, do you think it could be this part of my body that's causing this? Well, that's not my specialty. You now got to go to this specialist. They can't even think outside of their own little box. Now, when you're looking at the portals, Dartmouth Hitchcock does have a children one. In fact, I was just talking to a parent yesterday, her child, and I think she submitted testimony, type 1 diabetic. You are stuck in the state of New Hampshire. The only people you can go to is Dartmouth Hitchcock. They're the only endocrinologists out there for pediatrics. She needed to review what had been said in the doctor's appointment. These are all the notebooks. And this is only till first 2 years of what I have to keep and track of and understand what goes on in a doctor's appointment. If I don't have access to the patient and the summary that happens from the doctor, I can't go back and check. There is no way when you're in there that you can take proper notes. A lot of them will not let you record. Dartmouth Hitchcock does not allow you to record. So how are you supposed to get accurate notes if you can't compare what you wrote down with what the doctor said? Your child doesn't know how to do this. She was denied access to her child's records. So now she has to now take a 45-minute ride back in there with her child to sign some document that she wasn't even aware that she all of a sudden was not allowed access to. She needed to know exactly what the settings needed to be on her insulin pump and to double check with what the doctor had suggested. That's a big deal. If you are giving your child too much insulin, that's a life or death situation. When my daughter was first at Dartmouth-Hitchcock, we don't go there any longer. We did have access, and I
20
did have
seconds.
access to her portal. And then they said, no, she has to have her own access. So it was easy enough that we could go and just set up her own portal, and she shared her username and password. Now they have a huge amount of documents and forms that you have to sign. And it's legalese. These kids that have a rare disease or any medical condition, they can't handle it. They're just trying to live their life. They can't handle all the medical decisions. They cannot understand it, nor can they understand the long-term implications of any of this that is going on. My daughter is now of age, and I'll tell you right now, she still looks at the doctors and says, just talk to my mother. She knows this stuff. She knows what's going on. Don't bother me with this. She's like, I'm just trying to survive here. Thank you.
Thank you. I have a question for you if you'll take it.
Sure.
The question is, how were you able to access all of this information without this legislation?
Because the portals were open back then. We're going on over 10 years of doing this. So things have changed in 10 years. So we saw probably maybe 5+ years ago that the portals and stuff were starting to be locked down and that parents weren't having access, and we were getting letters. I was also getting letters from Boston Children's Hospital. And again, the age changed. It was like 14, 15, and then all of a sudden it went down to 13 and 12. So it's been changing over the years. So this is a 10-year journey that we've been on.
Thank you.
No problem.
Any further questions? Seeing none, thank you very much for your time and for those sugar cookies last week.
Oh, thank you. Just to also reiterate, I didn't say that, yes, I'm on the New Hampshire Rare Disease Advisory Council. I am representing myself. I am not representing the council. I'm glad you enjoyed the cookies.
Thank you.
Next year, or you can come to the governor's office at 1 o'clock. We're doing our proclamation. And if you have time on Saturday at the Red River Theater, if you really want to see what rare disease patients go through, the movie Complicated is being shown free of charge at 10 a.m. So you can get there at 9:30. They have amazing popcorn at the Red River Theater. And you can see front and center what a rare disease patient goes from trying to get diagnosed all the way to finding possible treatment. But 95% of rare diseases do not have any FDA treatment possible available to them.
Can you email us the information that you explained, how you got the information and the fact that the laws are different now and the information for the Red River Theater? And the information for the Red River Theater.
I'm not sure that, I'm just saying the portals have changed over time. It's not a law or anything. I've just noticed as going over the past 10 years, the portals and the access has changed.
Okay, so I'll make it even easier for you. Can you just email
Red
us
River.
the information about the theater?
No problem.
Thank you kindly.
No problem. All right.
And our final pink card is for Liz Canada. Thank you and welcome. You'll have 3 minutes.
Oh, thank you. I think I only asked for 2, so very luxurious. So,
See?
good afternoon. Thank you. Very generous. Thank you. I wasn't preparing to speak necessarily. I was listening in, and I wanted to focus. My name is Liz Canada. I'm the advocacy director for Planned Parenthood New Hampshire Action Fund, Planned Parenthood Northern New England. You can tell I haven't prepared. I wanted to focus on a few things that I heard to just address. So the first thing is many young people under 18 talk to their parents about their health care, talk to their parents about birth control, talk about sexual activity. They do that. Many of them do, but some don't. And right now, teens are able to access birth control confidentially in New Hampshire. Many of them talk to their parents, but not everybody. And that's really important. New Hampshire is one of the states that has the lowest teen pregnancy rates in the country. We should be really proud of that. And that's because of the ability to access that health care. So that's the first point I wanted to make, that many teens do talk to their families about that. The next is about federal and state law. I heard some questions about the exceptions that are built into this bill. So the federal law that allows for confidential access is Title 10. There are only some healthcare providers in the state who are recipients of Title 10 funding. Title 10 is the nation's family planning program. It requires the providers that get this funding to offer confidential services to every patient, no matter the age, that they have to offer confidential services. Point one that I made is still true. Many talk to their families, but not everybody. And Title 10 requires those confidential services. But that's the only law that allows for confidential services. So if this were to pass as it is, there's no state law saying that teens can consent. So the federal law would only stand, and that's only for the Title 10 providers. That would mean that if a patient is going to a provider who receives Title 10 funding, under this, they're able to get their health care, they're able to have that confidential access without being compromised. If a patient is seeing their primary care provider, who they go to all the time, and they talk to the primary care provider about birth control, now that record, if this passes, that record is no longer confidential. So they wouldn't be able to adapt to that. But the Title 10 providers, that's still in effect from Title 10. So want to just reiterate that it is really important that teens be able to confidentially access birth control. Many talk to their parents, but maybe not right away. They're still going to be sexually active. We know that from all of the data. We want to make sure that they get the health care that they need. I hope that addressed some of the things, and I'm happy to take questions.
Representative Rice.
Thank you, Madam Chair. Thank you for taking my question. Thank you for being here today.
Of course, thank you.
So, okay, so I'm trying to wrap my head around this Title 10.
Yes.
So this isn't necessarily a law unless you technically opt into it for it's basically a financial incentive.
Thank you for the question. Title 10 is a program that some healthcare providers are a part of. So they receive funding through Title 10. So they offer their health care as part of those rules and expectations under Title 10. So it's not that a patient comes and is like, I'm going to be part of the Title 10 program. They're Title 10 providers and offer those services regardless.
Follow up?
So when they sign on to be a Title 10 provider, they're doing it with the financial incentive that they're going to get, correct?
Thank you for the question. So there's no signing up. There's a lengthy contract process to apply and so forth. There's a lot to it. And they have to follow all regulations and all of the rules and so forth that is there. But there is some funding that comes from Title 10. It is not a lot, but it is something, and it is meaningful to the providers who are in it, certainly.
Representative Rung.
Thank you, Madam Chairman. I have a question about the Title 10. So if this were to pass, does that present a conflict then with those providers because they still have to comply with the Title 10 confidentiality, but then by state law, they would have to make those records accessible to the parents?
Thank you for the question. The way that I read it, and I am not a lawyer, the way that I read it is that the Title 10 providers would still be able to have that confidential services and medical records because of Exception A. It's for all the other providers who, like your OBGYN or your family care provider, who would not be able to do that. The providers that the patients know really well. Yeah.
Representative Raymond.
Thank you, Madam Chairman. Thank you. I know we're running into lunch. What about HIPAA?
thank you for the question, and I am not a HIPAA person. I can get information and share it with the committee. I'd be happy to do that, but I don't have anything ready. Like I said, I was not necessarily ready to testify today, but I'm happy to look.
Okay, thank you.
Thank you very much for your
Thank you.
information.
Have a great rest of your day.
Thank you. You as well. Having no more pink cards and seeing that we are pretty much finished with House Bill 1378, I'll close the hearing, and I will apologize that you only have 45 minutes for lunch now, so you have to be back by 1:30, or actually 40 minutes because we need to start heading back by 5 minutes early. Enjoy your lunch. Thank you, everybody, for indulging. I know that we're about 2 minutes late. These little legs don't move as fast as they used to. Anyway, thank you, everyone, for coming, and I'm going to open the hearing on House Bill 1565, and I see that Representative Ayers is... Oars?
Like boat oars.
Thank you for correcting me. I appreciate it. Representative Oars is at the testimony table, ready to introduce the bill on behalf of the sponsor, Representative Spillane. And you have 3 minutes, sir.
I don't get the 1 hour I wrote on my pink card?
That's tomorrow.
Oh, that was for tomorrow.
Yeah.
Okay. All right. Well, thank you very much, Madam Chair. So, yes, I'm here on behalf of James Spillane, and I'm a co-sponsor on this bill. The proposal is not new. It's not an experimental type of piece of legislation. This has been introduced several times over the last few years and has passed the House several times. It was passed bipartisanly. It also passed in the Senate, but died in a committee of conference. The problem hasn't gone away. New Hampshire law currently penalizes knowingly false reports in some circumstances, but individuals still use this method to weaponize against mostly the children. We have, custodial disputes, neighbor conflicts, personal vendettas, people that'll retaliate against professionals or public officials. And these complaints are not just an inconvenience. They trigger investigations, house intrusion, more emotional trauma for the children and for the families, of course. And we also, we know that the greatest victims of this is usually the children, even more than the family because of their age and, their innocence. So we don't want the system to weaponize, and we don't want the children to be repeatedly interviewed if it's not necessary. So we would like to, move this legislation forward, and we want to be able to, focus on these false reportings, which would mean, less real abuse cases. We don't want to neglect good investigations, and we also want to protect children and high-risk children. So the bill is really about protecting the integrity of the child protection system. And what it actually does is it creates penalties for individuals who knowingly make false reports. That's the whole idea. It doesn't really change the basic structure, except for it's going to penalize false reporting. Not mistakes, not good faith concerns, but false reporting. It targets the malicious
30
actors
seconds.
only. Wow, you threw me off with that. Okay, so the bill does not discourage legitimate reporting. It does discourage abuse of the system. And with that, I'll be glad to answer any questions that you would like to put my way. And I am, by the way, Representative Sir Orrs Merrimack 13. So
You were under your time, even though I threw you off, so you're good.
thank you, Madam Chair. I would like to reclaim my time for later. Just kidding.
Okay, tomorrow.
It's always tomorrow.
Representative Raymond.
Thank you, Madam Chairman, and thank you for taking my question. My question is about some of the language changes in the bill. And I do see that you guys added my complaint from previous years about making a penalty for people who don't report when they should report. But my question is about line 10 on the first page of the bill, where it says in bold, reports made to the department may include the name, address, and phone number of the person. So my question is how this will change practice can people still call in anonymously? One. And two, can people call in and say, I'm going to give my information to DCYF because I want to be available for them to call me back if they have questions, but I don't want the family to know that I have called them in because I'm their next door neighbor and I'm worried this will wreck our relationship.
Well, I think that's a very good question, which I am not, it's above my pay grade to answer. But I believe Representative Janine Notter, who's sitting behind me, maybe she would like to answer that question because I believe she would have the answer to that.
Okay, we'll put a pin in it.
Representative Pearson?
Thank you, Madam Chairman, and thank you, Representative, for taking my question. This is, would you believe, I've been doing a lot of study of law, I really have, and enjoying it, and I'm not going to law school. But I have learned that intentionality is a high bar of proof. And therefore, do you believe from that, it should alleviate any concerns about someone who thinks, oh, what if I make a mistake? Because intentionality has to be proven that they did it falsely on purpose.
Yes, yes, I would agree with that. Thanks for the question. I would believe also what this does is it puts enough teeth in the statute that maybe somebody that would false report would think twice before doing it.
Yeah, thank you.
Thank
you.
Any further questions? Representative Rice?
Thank you, Madam Chair. Thank you for taking my question. Does it state in the bill that they have to take the name and number for every person that calls, or if they see, or could it be requiring this if they see a pattern for one family that keeps getting called on?
So thanks for the question. Again, I'm going to refer to Representative Notter, and I'll let you ask the same question as I'll let Representative Raymond ask the question again to her.
Okay, so then would Representative Notter fill out a pink card?
I'm sure she'd be willing to do that for us. She's really good like that.
She is very good like that. Okay, any further questions? Representative Love?
So just to be sure, would this bill be a start to getting truth into our child protective services system? You know, the family court's often referred to as liar's court. There's no perjury charges ever brought. And the judge is left there trying to figure out who's lying the most. Would this be a step forward in working on that problem?
Yeah, thank you for the question. So I believe currently that, we do have a lot of honest players in that arena, parents, so on. But of course, we do have some bad actors. We know they're there. We've seen the patterns. We've seen the outcomes. And so like I said earlier, this bill would be a good start in putting enough teeth into the legislation that hopefully they would think twice before even going down that road. And that in itself should, take some of the pressure off that whole process.
Thank you, sir.
You're welcome. Thank you.
Any further questions? Seeing none, thank you very much, Representative Orr.
Thank you, Madam Chair, and I will not be here tomorrow to reclaim my time. So
Oh,
I'm just
well,
gonna,
it runs out at 6 a.m. in the morning. Next, I'll call Representative Bestie, also known as Representative Notter.
I'm looking around for Representative Bestie. I thought you said Vesty at first. I'm like, good afternoon, everyone.
No, nobody had any alcohol at lunch today that I know of.
Neither have I, just a mega dose of vitamin C. All right, so your first question was,
Representative Raymond.
Do they have to give?
Thank you, Madam Chairman. Thank you for asking me for my question again. So my question is on the bold language on page 1, lines 10 through 12. It says reports made to the department may include the name, address, and phone number of the person making the report. So does this mean that people can still call anonymously, 1, or 2, can people call and give DCYF the information so the worker can follow up with them, but ask to remain anonymous to the family?
Right, it says may, not shall, so they can be anonymous if they choose.
Right, so follow
I
up?
believe.
Follow up. Thank you. If someone was a bad actor calling knowing that they were making a false report, why would they not always be anonymous so that they could not be held accountable for their bad behavior?
Repeat that.
So if somebody can call anonymously, knowing there's a criminal penalty for lying to DCYF, and they can be anonymous, why would they not always be anonymous and thus avoid any repercussions that this bill would create?
You would have to ask the people that make the false accusations. Can I go on? I'm co-sponsoring this bill because I know of a homeschool family who had false accusations made against them, and their children were taken away just based on a false accusation. And that's wrong.
Can I follow up? I don't disagree with that. However, I don't see any relief for that family if the person avoids accountability, if they simply refuse to provide their name when they call the hotline. They could call every day and lie and just say, I would like to be anonymous. And then the family can't sue them and they can't be referred to the police because no one knows who they are. Or would you believe that that is a flaw that I see in the current language?
So I can respond to that. We heard testimony before from the experts in the field when they appeared before us last year and the other many years that we heard testimony on similar bills. When you call with a complaint, they do have caller ID. And if those caller ID, on the caller ID, the number comes up frequently, they start an investigation into, and the complaint is totally unfounded, and there's no problem with the family. That's when they go back and they see all these phone numbers, and they can investigate. They don't always, but they can investigate. So that's the best we can do with what we have, because we don't want to stop people who have legitimate complaints from calling. And this is, quite frankly, the language that the Senate agreed to. And the reason that the bill did not pass and was killed in committee of conference is because there were 3 bills that had nothing to do with this bill that were absolutely thoroughly outrageous. So the conferees decided to vote no on the committee of conference. One of those bills was to hang portraits of certain individuals. And we were like, no. So that's why. Thank you. Represent Love and
To answer Representative Raymond's question, we do have voice recognition technology today. Law enforcement has it all the time, and I imagine DCYF might have to borrow it if that happens a lot. If they start hearing the same voice.
thank you, Representative Love. Representative Nelson.
Thank you, Madam Chairwoman, and thank you for taking my question. Would you believe that some false reporters do identify themselves on purpose because they're in high conflict disputes? They want to prove that the other parent is wrong or bad, and sometimes it's a misunderstanding of normal parenting behavior.
I wouldn't know how to answer that. I'm not sure. I'm not sure.
Perfect answer. Thank you.
Am I done?
Thank you, Representative.
Representative
Great job.
Dusty, at your service. Thank you.
Feel better. The next pink card is not representative. The next pink card I have is for Miss Childs. Dr. Childs.
Good afternoon. Thank you, Madam Chair and honorable committee members. My name is Deborah Childs, Dr. Deborah Childs. I'm Executive Director of Time to Put Kids First, and I'm speaking in very strong support of HB 1565. For 3 decades, I've worked with families navigating some of the most painful and complex life experiences imaginable. Most victims of false allegations never speak out publicly, carrying the weight in silence, ashamed, terrified of retaliation, desperate to rebuild shattered lives. We dread the fallout, rippling to everyone we love, our closest friends, our aging parents. Above all, we shield our own children and grandchildren from the poison of those details. I've looked into the eyes of a woman who spent years fighting to free her father from prison after more than a decade behind bars, imprisoned because she was coached as a child to repeat the lies that put him there. I've heard the desperate plea of a father begging the court not to subject his 18-month-old daughter to yet another traumatic rape kit, all because of vicious, horrific, baseless accusations. These are not, sadly, isolated horror stories. They reflect a serious and recurring problem. And until bills like HB 1565 force accountability, families will keep paying the price in broken trust, lost years, and innocence stolen. A false report is not simply a mistake on a form. They instill fear and uncertainty in the developing mind of a trusting, naive, and impressionable child. They can launch traumatic investigations, isolate a child from a parent, and permanently damage reputations, even when the allegation is later proven false. The damage lasts a lifetime. False claims also harm the very people our system exists to protect. When they become common or widely discussed, real victims of abuse suffer. They hesitate to come forward out of fear they won't be believed. False claims are a misuse of the legal system. Approximately 45% of reports are not accepted for full investigation because they do not meet the criteria for suspected abuse or neglect. Of the remaining approximately 50%, only 7% are proven true or supported by sufficient evidence. Though it's not about fewer reports, it's about honest ones. HB 1565 deters intentional falsehoods.
30 seconds.
So we can direct every resource we have to the children who truly need protection. The key word in this bill is knowingly. Being wrong is not a crime. A report that can't be substantiated is not a crime. A concerned teacher, doctor, or family member who genuinely believes a child may be in danger remains fully protected. HB 1565 applies only when someone knows the information is false and reports it anyway. The legal standard is intentionally high. It doesn't weaken mandatory reporting laws, it doesn't reduce protections for children, and it does not discourage people from reporting genuine concerns. On behalf of my son and granddaughter, my grandchildren, my children, on behalf of myself, my family, and all survivors of false allegations, I urge the committee to recommend OTP on HB 1565. Our families, and especially our children, deserve a system that balances strong protections with meaningful accountability for abuse of that system. Thank you for your time in considering this important legislation.
Thank you. Representative, will you take questions?
I will.
Representative Nelson.
Thank you, Madam Chairwoman, and thank you for taking my question. Would you believe that nearly 30 other states in the United States, blue and red, already have this type of protection in law?
I would.
Seeing no other hands, thank you very much for your testimony. We appreciate you being here today.
Okay, and I'll send my full testimony and my personal story online as well.
Thank you kindly. We appreciate that. Next, I'll call Representative Barton.
Thank you, Madam Chair. I'll be quick because I have a bill coming up right after this one. I'm not going to take any questions. I just wanted to say that I'm very aware that DCYF receives all kinds of false reports, and it's a burden on them. I think this legislation would prevent that burden, and I know several other states, Florida is one of them, that has a law against filing false information or essentially weaponizing this department against another parent. And I think that this aims to prevent that. And so I support the legislation, and I hope you all do too. Thank you.
Thank you. Having no further cards left, I will close the hearing on House Bill 15.
Did you fill out a pink card? No, they have to.
It has to come up this way, ma'am.
No, I'm just looking for.
Thank you. The final pink card that I have is Denise Costello. And just for the rest of the audience, if you do want to speak, you have to fill out your card, give it to the first person on that side so that it can reach the chair. Thank you very much. You can come to the testimony table, madam, and you'll have 3 minutes.
Good morning, Madam Chair and members of the committee, and thank you for the opportunity to speak. My name is Denise Costello. My residence for the past 39 years is Concord, New Hampshire. I am testifying in support of House Bill 1565 and enacting accountability and consequences for the emotional and psychological abuse of children resulting from the tactics and strategies employed by one parent trying to undermine and destroy the relationship that child has with the other parent. It's important not to ignore the prevalence of false allegations and the devastating effects on children and families, which include emotional trauma, financial hardship, irreparably damaging reputations, and most importantly, the strain of the parent-child relationship, restrictive custody during investigations, and resulting in unfair custody arrangements. Bad faith false allegations are rooted in a desire by one parent to gain leverage in custody hearings, revenge, or anger toward the other parent, money, and mental health issues. There is no better example of how false allegations negatively affect children than in the case of a parent who makes false statements about a child's well-being by demonstrating Munchausen syndrome by proxy. This is known as fictitious disorder imposed on another and is listed in the DSM-5. Is considered a form of severe medical child abuse. In all cases, the priority is protecting the children. Enacting House Bill 1565 is a crucial step to protecting the children in cases of false allegations and subsequent repeated investigations. Parents who make knowingly false allegations harm the child and disrupt the child's relationship with the other parent, causing additional time in court hearings and other proceedings. In Masters v. Masters, a mother falsely accused the father. The court found that the parent coached the child concerning false allegations of abuse, which bears negatively on a parent's moral fitness. The court further found that a parent who knowingly alleged false abuse allegations would continue to thwart the parent-child relationship. The comment from the court decision is, when one parent embarks on a planned course of action to destroy the parent-child relationship between the child and the other parent, this is not in the best interest of the child. When that course of action involves planting in a child's mind knowledge of sexual practices that cannot be reasonably associated with sex education, and the inculcation of that knowledge is falsely attributed to child abuse by the other spouse,
It takes no expert to realize that the resulting damage to the child is incalculable.
30 seconds.
A parent will deliberately use such means to further selfish interests in acting in his or her own interest and not in the child's interests. Civilized people abhor and condemn sexual child abuse, bringing false charges of parental sexual abuse of children and the deliberate use of the children as pawns to try to validate the charges is equally despicable and condemnable. Misdemeanors in New Hampshire include disorderly conduct, trespass, shoplifting, yet there are no consequences for making false reports to government agencies, DCYF, family court, and law enforcement. False allegations is the vacuum where the weaponization of children thrives. This bill provides consequences for bad faith, false
Thank you, Madam.
reporting,
Time is
and
up.
pardon me?
Time is up.
Okay.
I'm sorry.
I only had another sentence.
Okay, read it.
May I? The bill provides consequences for bad faith, false reporting, and restores accountability. If you believe DCYF, family court, and law enforcement are overwhelmed, then you should pass this bill by removing the incentive to weaponize children and the systems in place to protect them for leverage and custody disputes. The bill helps return limited resources
you.
to DCYF, law enforcement,
Thank
and the
you for
family
your
court.
testimony. I appreciate it. Any questions? Seeing none, thank you for your time and your testimony. If you can pass that, did you pass written testimony in?
I will. Right
Thank
now.
you kindly.
Thank you. I appreciate it.
Having heard the last person to speak on House Bill 1565, I'll close the hearing on that. And I will now open the hearing on House Bill 1757. I'm going to ask the prime sponsor, Representative Barton, to come forward and introduce the bill.
Thank you, Madam Chair. Representative Barton, Grafton District 1. Thanks for letting me submit the testimony. I have written testimony coming around in support of House Bill 1757, prohibiting the remedy of alimony for marriages that existed for short term, for 6 years or less. House Bill 1757 establishes a clear statutory boundary. Term alimony and reimbursement alimony may be ordered only where the marriage lasted more than 6 years. This reform restores proportionality, predictability, and coherence to our New Hampshire framework regarding alimony. Marriage in New Hampshire is voluntary. It is both a personal union and a civil contract recognized by the state. Adults freely enter into it. When they do, they accept mutual obligations. When that contract is dissolved, however, that legal system must ensure that post-dissolution remedies remain proportional to the duration and the depth of the partnership that existed. Alimony is a statutory remedy designed to address economic inequities created by sustained marital interdependence, particularly where one spouse has made long-term career sacrifices or financial contributions in reliance on the marriage. That justification is time-based. So in marriages of short term, 6 years or less, the degree of entrenched economic reliance is generally limited. Both parties typically retain proximity to their independent earning capacity before they got married. Career trajectories haven't really been permanently reshaped. There's no long-term dependency structures that have been formed, and this bill recognizes that essential reality. Short-term marriage should not produce long-term financial obligation absent compelling reliance interests. When two adults voluntarily enter into and voluntarily exit a marriage within a relatively brief period, the legal system should disentangle them fairly, not perpetuate economic dependence. So this bill promotes proportionality by aligning the availability of alimony with the duration of the marital partnership. In addition, lawmakers must acknowledge that legal remedies shape incentives. While most divorces are driven by personal and relational factors, statutory frameworks can influence the economic landscape of dissolution. A public policy should not structure divorce in a manner that creates unintended economic advantages or disadvantages based solely on duration thresholds that lack proportional grounding. Alimony is not a constitutional right, it's a statutory creation. The legislature defines its contours. It's entirely appropriate for the general court to clarify when that remedy is available to ensure that it remains tethered to long-term reliance rather than applied broadly in short duration unions. Marriage is serious, divorce is serious, and the remedies that follow should reflect both seriousnesses and duration. House Bill 1757 preserves alimony for marriages where sustained
30
partnership
seconds.
justifies ongoing support while preventing short-term contractual relationships from generating disproportionate post-dissolutional obligations. In summary, this bill restores proportionality between duration and remedy, reduces costs in litigation, preserves alimony as a targeted reliance-based doctrine, avoids unintended incentive distortions in brief marriages, and maintains full property division and child support protections.
Thank you. Will you take a question? Please.
Yeah, I'll take a question.
Representative Rice.
Thank you, Madam Chair. Thank you for taking my question. So would you believe I have a daughter who was in a relationship for 5 years where they had 2 children. They then got married. During this time, she was staying home with the children after she quit her $60,000 a year job. Now, when they just ended up getting divorced because he was abusive, she needed some income to help her get back on her feet and be made whole again to get back to her $60,000 a year job. Would this legislation prevent that from happening?
No, I'm sure there would be more than adequate child support to help her raise her children, or maybe put them in childcare so she could go back to her original $60,000 a year job. I don't want to conflate the issue of child support with alimony. This bill does not target child support at all. Child support is still an obligation.
Are you aware of the cost of childcare? Do you think that child support would cover the cost of childcare, her getting an apartment, being able to make her bill payments and her car payments?
What was the question? Am I aware of how much it
Of
costs?
how much childcare costs?
Yes, I am aware. I do have a child.
Representative Raymond.
Thank you, Madam Chair, and thank you for taking my question. So my question is just about the 6-year time frame. Most states say if you've been married for less than 10 years, you get about 50% of the length of the marriage in alimony. A lot of states say more than 10 years, it can be a little bit flexible. Where did 6 years come from?
6 years is a standard short-term marriage definition, and I want to be clear too. This also includes the time of the filing. If you file, it's not from the date of filing; it's from the date you get the final decree. So really, the parties may only be together for 3 years, and then they're duking it out for another 3. And so, I mean, you should have things figured out.
Okay, just a follow up. So I did a lot of research because we had a snowstorm, so I had time yesterday. I couldn't find any state that said 6 years or 8 years. I found a 10-year statute. I found one about 5 years. I found nothing for 6. So I guess you said 6 is like a standard short-term marriage, but I can't find that. So are there any other states that have something similar where they say up to 6 years or even say 10 years, you get nothing?
I'm sure there are, and I'm happy to email you the research.
Okay, thank you.
Representative Miller.
Thank you, Madam Chairwoman.
and thank you for taking my question. I feel like some echoes of one of the earlier bills that we heard today with respect to this in how it limits the court and restricts the court from making a fair decision. And so my question is, we trust the courts to hear both sides, to deal with the negotiations between the parties.
Maybe
and
you trust the courts. I don't trust the courts.
If you'd allow me to finish.
Yes.
The courts are responsible for hearing both sides of the evidence, hearing the discussion, and making a judgment. With this bill, we would be removing an option from the courts that is currently available to them. And so in the interest of fairness, I'm curious why we should hamstring our courts and hamstring the process versus allowing it to continue to work in the manner that it has been successful thus far.
Yeah, I'm happy to answer that. Why do we have any guidance or regulation? Why don't we just let the parts go to a court and let the judge do whatever they want with the parties? Why do we give them, as a legislature, why do we provide them any guidance whatsoever? If you're saying that we shouldn't give them clear guidance with something like this, I don't understand why you would argue against our job as legislatures to give the judiciary a swim lane. This tightens up the swim lane. It makes things more fair for really short-term marriages. Alimony is an extreme remedy, but judges hand it out left and right. And because there's no rules of evidence in family courts, because there's full discretion, there's no guidelines. This just puts a guardrail for really short-term marriages, well less than 10 years.
Representative Raymond.
Thank you for your indulgence, Madam Chair. I thought of another question about this, and that is about voluntary agreements, because we know that in 80 to 90% of divorce cases, parties come to an agreement themselves without needing the judges to say this is what you must do. So would this still allow for the 80% of people who come to an amicable agreement to decide that alimony will be part of that?
Absolutely. If one party wants to pay voluntarily alimony to the other, this would not limit that at all.
Even though it says the court may order it only if the marriage has been longer than 6 years?
That's a court order. That's not an agreement between the parties. If the parties come to an agreement, great, they can do whatever they want. This is with respect to the court ordering.
Are you aware that in order for the divorce to become final, the court has to order that the agreement made between the two parties is acceptable to the court and the law?
Yeah, and of course.
So your statement prior to said it was only if the court orders.
It's the language in the bill says may.
Thank you, sir. Representative Corzine.
Thank you, Madam Chair. Thank you for being here. So I think I'm kind of still stuck on the 6-year thing. How does making a carve out for 6 years or less make it any more fair or less fair than just what we have now, which is 50%?
It takes it to 0 for 6 years or less.
Right. Sorry, follow up.
Follow up?
Right. That's kind of my point, is that why are we carving out 6 years or less? It could take months for one party to lose a lot of money by not being able to accept a position or whatnot. We don't know what one person's giving up being in the marriage. I guess I don't understand the carve out for 6 years or less.
And I spoke about this in my testimony. The carve out is really to remove the incentive. Like I could marry a billionaire woman and then divorce her, and now there's a huge difference in our incomes. And even if it was short term, I'd be making out like a bandit. And I don't like having that incentive on the books for short term marriages. I think if you're going to be in it, you should think about it before you enter into that voluntary contract. And the state shouldn't incentivize a short term, a marriage that's short term, and then it's divorced by offering one party alimony. So, I mean, if I was very wealthy, I'm not people on YouTube. If I was, why would I ever get married? I mean, even if I wasn't wealthy, I would ask that same question to myself. But why would I ever get married when, if something happens, it's instant alimony for however many years, for 3 years. I don't think it's fair.
Thank you. Not seeing any further questions. Thank you so much for your testimony. I do not see any further pink cards, so I will. Sir, you have to pass them on. Well, I'm sorry. We're 15 minutes into the hearing, sir. Okay, have a seat.
Good afternoon. My name is Robert Lawless. I'm from Pembroke.
Robert Lawless.
Yes.
Thank you. 3 minutes.
I think this bill is a bill looking for a problem that doesn't exist. We have judges. They've done this job for a long time. They have the expertise and the experience. So the other way that judgment factors into this is I would question the judgment of the bill's sponsors. Let me explain. The primary was convicted of resisting arrest.
You cannot talk about another person, sir. You can only
You
talk
know what
about
I-
yourself, sir, and the bill.
Okay. Bill is a problem that doesn't exist. Let judges do their job. That's all I have to
Thank
say.
you very much, sir. Just for future reference, we can never assign motive for anybody's bill. That's part of the rules. And that's the only reason we can't accept testimony. They do have First Amendment rights. We are respectful, so if you want to continue to speak about your testimony, sir, please don't leave without getting your voice heard.
Just be respectful.
Just don't name names.
I didn't name a name.
But, okay? Thank you. Okay, so your 3 minutes will start again. Good afternoon, sir.
Good afternoon. Again, I guess I'll keep this will just be really short. I think that this is about judgment, and there's very poor judgment, I believe, in some of the previous testimony I've heard having to do with this bill. This bill doesn't need to pass. Let the judges do their job. Let's solve some real problems. That's it. Thank you. I'd love to.
Any questions?
No? Thanks for letting me.
Very good. Thank you,
Listen to
sir,
the
and thank you for coming today. Sorry for the confusion. With that, we're going to close the hearing on 1757, and we have a 15-minute break.
All right.
recognize Representative Pearson to read something that he got from the Labor Commission during concerning one of the bills we heard today.
Yeah, let me find it first. I should have asked that.
Sorry, which bill so I can pull it up?
This is on the bill on military pay.
Thank you.
And the question was raised about, do you have to get time and a half for a certain number of hours, even if you're salaried? So this is from Kenneth Merrifield, the Commissioner of Labor for the state of New Hampshire. He said, after your request, I went back and watched this morning's hearing to get the gist of the question. We want to tread carefully because this is ultimately a federal question, but it is my belief that a bona fide salary employee who is exempt from federal overtime would not be paid for additional hours over 40 hours per week. The employee, however, needs to meet certain salary levels and duties tests to be considered legally exempt as a salaried employee. In other words, yes and no. He said, I hope this was some help. The true authority on this is the U.S. Department of Labor.
I'm so sorry. I have something to add, Madam Chairwoman.
Sure, please, go ahead.
Thank you. Sorry for my lack of decorum. I know personally, I started a job at a company where I was a salaried employee that got overtime, but to your point, I was then promoted to a different position, much higher level of salaried income, and I no longer was eligible for overtime despite how many hours I worked. So that I just wanted to validate that.
Apparently, we have somebody like that that works for me. And actually, she's now moved from hourly to salaried. And what we found out was $35,000 was a threshold. If she got less than that, she would be salaried but subject to overtime. Over $35,000, she would not be. So again, it's Fed DOL that we need to chase down if it's that important. But thank you.
So can I ask a question then? Regarding this one where it says shall not include overtime compensation. I mean, we've just heard that if you make $30,000 a year or $32,000 a year, you can get overtime, right? So I still find it confusing and problematic.
That is his ultimate conclusion, is check with feds on the specific rules.
If I may, and I apologize, I was actually out during that testimony. I had a work call, but I happened to have reason to review the city of Dover's payroll in the last week, completely unrelated to this, and then as a substitute, it's like, this is actually relevant. And as a municipality, they publish how much everybody gets paid. I'm on there because I'm a moderator, and I was curious how much I made. That's why I was looking at it for the year, how many elections I worked. But one of the interesting things is there are a number of very high paid positions, particularly the fire department, police department, where overtime is a significant portion of the salary. There's, if I remember correctly, there's one person who made more than 100%, who more than doubled their pay through overtime. There are a number in the 30 to 40% additional in overtime rates. And these are people where the base is, the filter I put on the base was over 50,000, and many of them, the base was over 100, and they were still making significant overtime as well. So I can offer that as something that people could go look for, pick your town or a nearby municipality if you need a longer list of things, but that would be some interesting research to consider. I am a really, really weird guy.
I don't think you're weird. That would make the rest of us kind of weird, though. But so I just looked it up and asked Mr. Google. And Mr. Google says salaried employees may receive overtime if they are classified as non-exempt, which usually depends upon earning below a certain salary threshold, less than 43,888 and up to 58,656,000. annually as of 2025. So these are the more recent numbers. Depending upon specific regulations or performing duties not classified as executive, administrative, or professional. Most high earning white collar salaried staff are exempt. So that's what I was talking about earlier was I know that there are some salaried positions who are eligible for overtime pay. So we can't put, like most of our legislation that comes before us, we cannot put all of our eggs in one basket.
Right.
Because like society, everything is diverse.
I'll say it out loud. So yeah, when I worked for Child Protective Services in New York, only Child Protective Services can remove children in New York, not the police. So the police have to call people at 3 a.m. or whatever. But we were salaried. We worked a 40-hour week. But on your on-call time, when you carried, back then it was a pager. This is how old I am. When you carried the pager, you got time and a half for the actual time that you were on the phone or had to go out. Because you didn't get an extra, you didn't get paid just to carry the pager. You actually had to do something with it. But yeah, so I was surprised to, and we used to trade it off all the time, right? Like the youngest people in the office got it the most, but you know, if your snowblower died and you needed to save up money, you could trade with people.
So that's a good thing. We learn something new every day. Representative Miller is weird.
I do miss
Representative
Buzz
Nodder
though.
changed her name from Bestie to Nodder and back again.
Yeah, that was good. That was good.
So we have a couple of more minutes to take a few deep breaths and then we're going to move on.
This would be a good time.
Did Representative Georges remind you to do that? Not that she's old enough, because she certainly is not old enough, but we consider her our committee mother.
Who's that?
Representative, the lovely Representative Georges. Representative Georges, we're going to call your daughter and tell her to knock off parking in the middle of your driveway, okay? Thank you so much, everyone, for your patience and waiting. It is now time for us to start the final bill of the day. Yay. House Bill 771 FN. And I'm going to call forward Representative Peternil. to introduce her bill.
Thank you.
Thank you, Representative. You have 3 minutes.
3 minutes, even for the prime sponsor? That's awesome.
Yes, ma'am.
We just had an hour-long introduction, so.
Don't use up your precious time. I will start as soon as you introduce yourself.
Thank you, Madam Chair and members of the committee. For the record, my name is Katie Pettinell. I represent the towns of Wolfboro and Tuftonboro, Carroll District 6. So I have House Bill 1771, which is removing the prospective repeal of childcare staffing ratios and the associated waiver system. So this system was meant to sunset. So this repeals the sunset and makes it a permanent waiver expansion. I see this as an economical way to help solve the childcare issue. Of course, it won't completely solve it, but I think each step in the direction is helpful. This would lower costs and rates while maintaining safety of the children. It only applies when there are 2 or more teachers already in a room. So, for example, if the ratio of 4 infants to 1 teacher would hold if there were 2 teachers in the room, instead of only being able to have 8 children, you could now have 9. So it doesn't significantly increase the number of children, but it does it a little incrementally, so you can have 1 more child. And I think each time we can add 1 more child, it makes life easier for the parents who are looking for childcare. The other thing, the other part of this bill is that it would require that the department provide an annual notice to licensed childcare providers of the option to request a waiver. And that is not something that DHHS does right now. And we think that this might increase the opportunities or the knowledge of this system. I'm not sure in line 10 if RSA 197.3 is correct, so I have to double check on which RSA that is, because I believe that's an education statute, so that might need to be amended. And did I make my 3 minutes?
Oh, yeah. Yes.
Okay.
You have extra time. You want to tell us about anything else? You can ask your question in a second if that's okay. I just have a quick question for you. Isn't this the bill that came out of the special committee on child care? And the purpose was to have a sunset date to see how it was going. And then hopefully we would make it permanent.
I believe so,
Thank
and
you.
I think that it was a little slow in the uptake, and maybe just by increasing this would be helpful.
Thank you very much. Representative Nelson.
Thank you, Madam Chairwoman, and thank you for taking my question. Madam Chairwoman and I were on that special committee on childcare, and I do recall that one of the other concerns that we had was we wanted to have the sunset in the event that that the decision was that it was not a good law, but we also wanted to make sure that because of the potential for problems or reports of issues. Are you aware of any negative reporting regarding this staffing change?
Not that I'm aware of.
Thank you.
Seeing no other questions, thank you very much for your time.
Wow, that was easy. Thank you.
You're very welcome. The next pink card I have is Melissa Clement. She's asked for 2 minutes. I'm going to be generous and give her 3.
Thank you. Oops, I'm sorry. Thank you, Madam Chair, members of the committee. For the record, my name is Melissa Clement, and I'm the chief of the Child Care Licensing Unit. And I don't necessarily have a full 2 minutes presentation, but I'm here to answer any questions you may have regarding this. I'm the chief of the Child Care Licensing Unit, so I'm happy to answer questions.
Representative Nelson. Sorry, Representative Rice.
Thank you, Madam Chair. Thank you for taking my question. So piggybacking off what Representative Nelson asked, did the sky fall when this went into place?
Thank you for the question. So we did file an interim report. I'm not sure if the members of the committee had a chance to review that. So we filed one in November of last year. And we had 5 requests for this waiver. And out of those 5 requests, 3 were granted and 2 were withdrawn at the request of the program because after consideration, they decided it wasn't necessary. So out of those 3 that were granted, the sky did not fall, as you termed it. And as far as notification, there was a notification that went out from Representative Ross Berry. He had sent an email to all childcare providers. So they were alerted to this as of, that this was an option available this year. And that was the response that we had for this year.
Representative Raymond.
Thank you, Madam Chairman. Thank you for taking my question. So I have a lot of questions because I wasn't on that board. So is this for center-based or home-based or both for childcare?
Thank you for the question. So the way the statute is written, it's for center-based because the language that's in the full statute includes the roles of center-based programs and those teachers and the ratios for center-based programs. And for further clarification, we have a waiver process already in our rules. So a provider can ask for a waiver for any rule that we have. So the waiver process itself is not new. That's always been established. So this statute just emphasized that you could request a waiver specifically for this type of ratio. But we would typically, review any ratios requests that we would receive under normal circumstances.
Follow up. Thank you. Thank you for your indulgence. So when was this waiver program supposed to sunset? I know we passed it in 2024. When is it supposed to end?
I believe it was December of this year. Okay. December 31st, 2026.
Okay, so December coming up, not yet. And then, thanks. So follow up. Thank you. So if only 5 daycares total have asked for it out of the whole state, and only 3 actually are, do we think it's helpful or necessary to change the whole statute instead of just extending the waiver?
I don't really have an opinion one way or the other. If it's in statute, we can certainly use the statute, but we have the process in the rule as well. So I don't really have an opinion on whether it's in statute or rule for that reason.
Okay. Thank you.
Sure.
Seeing no further questions, thank you very much for your time.
You're welcome.
I do see other people in the audience right now. Does anybody want to come forward to testify that has not submitted a pink card? Okay, since there isn't anybody else in the room that chooses to testify, I will close the hearing on House Bill 1771. Thank you, everybody. And I want to take notice that there are 3 substitutes in the room that came here today to listen to this testimony. And I really appreciate Weirdo Representative Miller, Representative Rung, and Representative Dargy.
Thank you.
Thank you so much for being with us today.
We meet on Monday, right?
Monday and Tuesday, I have slated for us to do exec sessions on all of the bills that we've heard. Some of them we may decide not to exec right away because we may want to do further investigations and get further information from our staff on those. So if you see a bill where you want more information and would like our researcher to get more research done for you, I'm going to not something I've ever done before, but I'm gonna give everybody on the committee the opportunity to email our committee researcher, but please BCC me. Or you don't even have to just CC me so that I know. And if she contacts me, which she's supposed to, I can let her know that I gave you permission to do that. Okay?
Do we have a Republican caucus at 6 p.m. Sunday night on Zoom?
Yes, we do. Sunday evening, Republicans caucus, 6 p.m. Please.
Madam Chairwoman.
Yes,
I should have asked while she was sitting there. Is that report, that interim report from November, do we know if it's publicly available or something that went back to that committee?
I don't know. Miss Clement. No, excuse me, Miss Clement. Is that report available? Could you? Okay. Could you please email it to the committee? Thank you kindly. You're welcome. Good call.